Following the matters of CP 2026-4, Amalgamated Security Services Limited versus Paria Fuel Trading Company Limited.
Okay. Slide next.
Good morning, everyone.
Good morning.
And the parties hearing, they hear me clearly. Dr. Rose, Mr. Carlson, yes. Thank you. So I am Sparkle, quick step. Yes, please.
My co-counsel, Ms. Smith, has not been accepted into the room.
We are not seeing her log on. Give me 1 minute. Let's check.
And it's Brandon. And also our instructing attorney, Mr. Brandon Ragnan.
Yes, please. So give us 1 minute. I'm not seeing those persons in the lobby. While we're looking, Mr. Tackler saying, are you all having any difficulty logging in?
No, we well, everyone is in my office, Chair. So we're all using one central computer, yes. So and Mr. Mahes is to my right, who has his own computer.
Great. Let's just check for the applicant's representatives, please. Thank you, Mr. Tackler. So, Dr. Rose, perhaps they are on the wrong link. Could you ask them to check the link because we're not seeing them in the waiting room at all?
We are doing that check. Apologies to the panel for this delay.
Chair, should I announce my my team's appearance in the interim?
Okay, we haven't started as yet. So okay, let me do the introductions to the panel, please. So we'll start because we have time constraints today while we wait on the applicants and attorneys. So let me introduce myself. I'm Sparkle Kirk-Selman. I will be presiding as the panel chair today. With me is Ms. Valerie Kelsick and Mr. Robbie Bullock. And we are the panel for today's hearing. Dr. Rose, you would like to introduce yourself and the other representatives who appear with you?
If it please you, Madam Chair, honorable members of the panel, I am Margaret Rose. I appear with Ms. Dana Marie Smith on behalf of the applicant Amalgamated Security. Mr. Brandon Raghunanan instructs us. Present on behalf of the applicant today is Mr. Russell Dalai.
Thank you very much, Dr. Rose. Mr. Taklal Singh.
Good morning, Chair. Kyle Taklal Singh. I appear on behalf of Paria this morning, the respondent. I appear with Mr. Stefan Ramkisoon, who is to my right. Mr. Mahes, who is also logged on. He's a representative of the company. And I just want to let the panel know I have a junior to my left, Mr. Matthew Alaha. He's just assisting me in taking some notes and in case I need to pull up any documents, etc.
So we're now seeing your co-counsel, Ms. Smith, and we'll admit her. Or she's admitted.
Thank you, Madam Chair.
Okay, now that we're done with the introductions, are there any preliminary matters that the parties would like to raise? Or before I start, the ground rules, you all would have gotten the rules via email, so you all should be quite familiar. In particular, pay attention that today is the hearing. And so when we start taking the evidence, all witnesses have to be out of court and hearing. If the witness is the representative, then they can stay after. They can stay on after. Right? We have to reduce all disturbances close to the microphone so that we get a clear recording of the proceedings today. Again, you're not to leave the room unless you seek permission of the panel, and you're not to switch off the camera if you're in the hearing unless you get the permission of the panel. So we will proceed with Dr. Rose. Do you have any preliminary issue to raise?
Yes, but I just wanted clarification on the presence of Mr. Russell Delay as the representative for Amalgamated. He is allowed to stay throughout, even though he is the witness. That is,
Yes.
okay, thank you.
Yes, because he's going to go first because the applicant will present. He's the only witness for the applicant, and the applicant will present its case first.
Yeah.
So he can remain after. Yes,
Before
Mr.
we
Rose,
get,
the preliminary.
yes, before we get into the presentation of the case, please, Madam Chair, we wanted to bring to your attention and the issue relating to disclosure. Pursuant to the panel's
please.
order, on April 17th, was it? On April 17th,
Yes, please.
yes, the panel ordered several categories of disclosure. In going through the disclosures that were provided to us by Paria, we saw several areas of reduction, and in particular, relating to the scores of the bidders in the course of this procurement exercise. And we think there were several other disclosures that were not made pursuant to your order, but certainly in respect of what the bidders that participated in this exercise scored and how they scored and where this applicant scored in relation to them, in my respectful view, pursuant to Section 5(1) of the Act, is required to be disclosed in the interest of transparency and accountability in this process, and for us to be able to effectively review the decisions and assist the panel in reviewing the decisions. Please. So that is a preliminary point.
Yes, please. So clarify, Dr. Rose, is it that you're saying that beyond what we ordered to be redacted, the respondent redacted additional information?
Well, I did not.
Because we did indicate in our order what ought to be redacted.
In my view, it would be in addition to what you have indicated.
Or alternatively, is it that you're saying that what we ordered to redacted should not have been ordered to be redacted based on the obligation under the Act?
I am not saying that. I'm not saying that.
Okay, just to be clear.
Madam Chair.
Yes. Okay, thank you. Let me hear from Mr. Taklalse.
Chair, what we did in complying with the order, we disclosed all of the documents. But the order had a clause 2. Well, it was introduced with subject. So all of the documents in the order was subject to the reductions identified in item 2. But then all that 2 said was to be cognizant essentially of Section 52 of the Act. So what we did is we disclosed all of the documentation, but we went on to ensure that it was subject to Section 52. And we gave a table of justification with it as to why. So that there was we received no order in terms of specificity of reductions. That's not the order we received.
Yes. Did you disclose the, sorry, so you're saying that the table was disclosed and was served on the applicant?
Yes, but we did redact parts of it because the way we got the order, it said that all disclosure remains subject to 52. It didn't tell us to go on and say, it didn't give us full guidance. That is, of course, no criticism of the panel or the order, but that's how we interpret it. And then we put with it, just out of caution, we put a table with it. We included a table, and we said, well, look, this is why, if there was further orders, we would of course comply. Yeah.
So Dr. Rose, as you have your co-counsel here, are they in a position to send us the specific issues that you have a concern with? While we
Yes,
proceed?
and I can also articulate it, please, because
Yes, please. Hold on, Dr. Rose, just now. Mr. Taklanse?
Yeah, just to add before, sorry, just to add before Dr. Rose continues. We disclosed to the OPR the full unredacted everything. So
Yes.
everything that we gave it was totally unredacted. We laid our cards face up, as they say in judicial review, to the OPR, and then we awaited guidance, so that at all times we were trying to comply as best as we could.
Yes, please. Thank you very much.
Yes.
Yes, Dr. Rose.
if we look at the order to disclose the PDAC report and the PDAC review report,
Yes.
in the PDAC review report, the respondent has sought to redact information on the evaluation scoring methodology has been redacted from the PDAC report. I am uncertain as to how my learned friend has arrived at the conclusion that that would be subject to Section 52. That is that part of it. We also do not have any information on the evaluator's notes, worksheets, spreadsheets, assessment sheets, evaluation records, nothing there provided. Then also, in respect of the full commercial breakdown of not just commercial and technical breakdown of the scores, not just of Amalgamated, but of the other bidders. It seems as if counsel on the other side or the respondent themselves do not appreciate what ought to be disclosed in order for the panel to be able to effectively review the decisions that were made. How, and for the applicant to be able to assist the panel to review this properly, how can the applicant be assured that it got the scores and got the ranking in respect of other bidders without seeing the other bidders' scores? We are not asking for commercial and technical information that the other bidders would have provided, but certainly for the fairness and transparency of the process, to have access to what was scored, who scored what, where are the evaluators' notes and score sheets, for us to have confidence that this exercise was carried out in a lawful and fair way for Amalgamated. And so I'm saying as a preliminary issue.
Mr. Taklanse, could you mute your mic when your friend is on her legs? Thank you very much, Dr. Rose.
Yes, and I realize we have very limited time, so I don't want to spend a lot of time on all of these issues, but those things were not provided to us, Madam Chair, and I'm asking humbly that the panel direct Paria to provide us with this information as soon as possible within the course of today so that we can effectively support the process.
In that vein, Dr. Rose, I'm glad you said it. We do not have a lot of time. I understand that Mr. Taklanse did in fact serve you with a table as to the reason why they redacted certain portions. That was served on the 17th of April. We now at the 23rd of April. We set for hearing today. Was it served when was it?
No, they did not serve on the 17th. I think that came
sorry,
into us
very
late. Yeah, very late on Sunday night.
On the 20th or the 21st.
Yes.
Right, yeah.
Yeah.
The 20th, sorry. But we're now on the 23rd. Every day counts for these hearings. In that vein, I've asked that you ask your co-counsel to send it to us via email, right? But we would not be stalling today's hearing to actually now deal with this. This was a matter that you could have articulated with us before so we can give it some consideration.
But please,
because we actually have to go through the particular sections, the particular redactions, and deal with your response to Mr. Taklanse's Given that he itemized it on a table indicating why they redacted, we need a response to the individual redactions and his support for it. So what I'm asking is perhaps you can ask your counsel to deal with that while we see how far we can get ahead.
Yes, we can, because no disrespect at all attended to this panel, but the panel will understand the pressure that we too were under on the 20th and the 21st, having to file 3 witness statements and 3 skeletal submissions back to back on consequential days. So in the skeletal submissions, we sought to indicate about not having all of the disclosures, but not in the itemized way that you are speaking to. So yes,
if we itemize it, we want you to go through each one and let us know. The thing is, we have a statutory duty to deliver the decision next week, Tuesday. So, and we are already at Thursday. And this is just 1 out of 3 hearings, out of, I think, 3.
4.
Right?
3
so,
panels, yeah.
yes, 4. Right. Mr. Tackler, do you have any response? Or you?
Chair, we could take it on a, if my friends said, if there's a response or the panel considers it, we could send it either today or later on, or at least in time for the other hearings. And we, so that, it could be dealt with. And if my friend needs to make a further submission in it, that's fine. But as I said, the panel has everything unredacted. If we get a direction or, like, for instance, the evaluation report probably with the scores, could be sent if my friend wants to see that. We're an open book. Yes.
Yeah, so once we get the email, they can perhaps email it to challenge management, and we could have a look at it during the course of the proceedings and see when we get it, we could probably then take a break at that time to go through it, and then we would be able to tell you which, but we don't want to not proceed on this matter, because this could have been addressed at an earlier stage.
Certainly not asking this panel not to proceed. In fact, Madam Chair, what I am respectfully asking is, I have just itemized that which we would like to have disclosure of. Mr. Taxalal Singh has very kindly indicated, if they want the scores, we can get the scores. This can be addressed right now. I just itemized verbally before this panel the areas that we would like disclosure of urgently. And certainly before the end of this hearing 1, if we can have the unredacted PDAC report as it relates to the evaluation scoring methodology, and if we can have the unredacted evaluation scores of the other bidders so that we can compare and rank and see if it was fair to say certain things, because they're very serious allegations in this case. And having regard to the disclosures, the allegations are even more serious. The little disclosure that we've had, it's even more serious, but we will get to that at the appropriate stage. So those are the 2 things. My junior will send the email immediately to challenge management for that. But I would like it on the record that these are the 2 areas that I'm asking for, particularly for this particular matter. And if it can come in before this matter closes, that would be very helpful. Or before I have to cross-examine the witnesses.
Yes, certainly. So what I'm saying is that once it is emailed, perhaps after your first witness, we would be able to take a break, review it, and ask for disclosure accordingly. But are there any other preliminary issues?
Well, I mean, I do think
Okay,
that
1 minute. I think Mr. Tackler thinks.
But Chair, I don't know if Ms. Rose had finished her preliminary issues. So then I could.
That's the first one. Do you have another preliminary issue, Dr. Rose?
Dr. Rose, I apologize.
Yes, but Dr. Miss, it's fine. I know, right? But I would, out of an abundance of caution, I will raise another preliminary issue. In my respectful view, at least in my respect and understanding the act and the powers that this panel has, I was not of the view that we would need to amend our application for relief for the type of relief that we wanted, because in our respectful view, this is not a civil matter. This is a quasi judicial matter with a regulator sitting under a jurisdiction defined by the Act. And your powers, the powers of the panel to grant relief, are not circumscribed and cannot be circumscribed by what the applicant asks for. The jurisdiction and power to grant relief is seized in the hearing panel pursuant to Section 5010, pursuant to the challenge regulations and the challenge hearing rules. And so in our relief, we ask under 5010H in our Form 8 from inception on March 26th for the panel to take such action as they deem appropriate, having regard to the circumstances of the case before them.
Yes.
And so in my respectful view, I did not think that we needed to make an application to amend our Form 8 reliefs to include the action that we are asking this panel, that we have now articulated, that we are asking this panel to take under Section 5010H, particularly, and I would say even more so, I would urge the panel not to view their powers and discretions in the way in which they're being urged by my learned friend in his skeletal submissions, because of the conduct of the respondent in these proceedings not to file a Form 9 for almost 2 weeks, waiting until, because we are all under pressure, Madam Chair and honorable members of the panel, not because of the applicant. We are all under pressure today to try to finish what we are doing today so that the panel has some sort of time to grapple in order to make its decision, not because of the applicant. It is because of the respondent not filing in appropriate time certain things. And so therefore, us not knowing what the respondent was going to join issue on, us not knowing what was going on with the respondent until April 14th. And even then we did not have the Form 9. It would be, in my view, unfair to the applicant to in any way suggest that the applicant that you ought to have amended your relief how long before, when in my respectful view, my respectful submission is, this panel is seized with jurisdiction under the Act, not by virtue
Okay, so
of
Dr. Rose.
Yes.
Thank you very much. But I think this is really something that could be ventilated in your submissions. I don't believe it's one that requires evidence from the parties, particularly. It's more a matter of law. So
Yes.
it could be fully ventilated in your submissions. And I don't mean to cut you across, but again, we're working with strict time frame. So thank you very much for your contribution. But I think this is one that you can ventilate fully in your written closing arguments. Mr. Takla, you want to respond?
Chair, just
before
Chair,
raising an next issue, you want to respond to this? Or?
Quickly to respond, we say yes, you're guided by the Act. You're a creature of statute. The Act has regulations. The regulation that we rely on is Section 15.2, which says that the decision of the office shall be confined to the issues raised by the application for review and written reply. That encompasses their grounds, the relief sought, and that document. So I leave that for written submissions. And of course, just to add that I think very recently the Supreme Court of the UK said that regulations aid in the interpretation of the statute. Apart from it cannot be contrary or ultra vires, it also aids in the interpretation. You have to read it as a whole. So moving on from Dr. Rose's point, she did raise an issue about the Form 9, just to say we filed our Form 9 as soon as we got service, meaning there were some issues with service. Unfortunately, soon as we got it, we filed it the next day. So and our new order was issued for that, which we did, and we complied. And of course, just to say that in terms of tangential issues or material issues which may arise, my friends were aware of the cancellation, and in fact, they do say so weeks before. So they could have adjusted if they wanted to adjust their relief, so to speak. I will just say in terms of preliminary issues, just to put on the record, Chair, and again, yes, are you hearing me, Chair?
Yes, but just 1 minute. Just to inquire from Dr. Rose, have you finished with all your preliminary matters?
One preliminary matter I wish to raise, Chair. Oh, I apologize. Are you the
Dr.
acting?
Rose.
Oh, Dr. Rose, I apologize.
Let me just make sure she's come. Dr. Rose has been.
Melinda, co-counsel just shared with me that we had specified certain things to be we're requesting disclosure, and I had not reiterated, and so just out of an abundance of caution, it will be sent via it's sent already, but we also want the portion of the PDAC report which has been redacted that had the evaluations, scoring, and methodology and commercial methodology scoring and all of that redacted. We would like that fully provided to us. So just putting it on the record, it has been sent via email. Yep. And that would be it for me on the preliminary issues, Madam Chair.
Yes.
Thank you very much.
Yes.
Thank you very much.
Chair, if I may, I apologize.
Yes, please. Yes,
Yes,
Mr. Tackleton, you may proceed.
My only preliminary issue has already been expressed to the panel by way of correspondence. I only asked the panel to note it. I just want to put on record, of course, the letters are not meant to upset the panel in any way. As we all know, sometimes lawyers have to take the points in the interest of their clients, and I have put it on record what my concerns were, and that's where I leave it. So I leave that there as my preliminary point, as a preliminary issue, which I have to put on record in each panel. So without further ado, I'm prepared to, well, I know that my friend has to lead the evidence.
Yes. So thank you very much. So what we can do, we have 3 witnesses. We could perhaps set a time limit so that to ensure that we keep on track. Would 30 minutes be sufficient for each of the witnesses? Ms. Dr. Rose. Actually, we should start with, well, yes. You have to do a brief opening statement of about 5 minutes, but before we get into the opening statement, Mr. Tackleton, would 30 minutes be sufficient for you to cross the applicant's witness?
I will attempt, I would say maximum 45 minutes, but 30 minutes, I will attempt to get it done in 30 minutes.
Right.
I know we are constrained.
Yes, so we'll put 45 minutes, and Dr. Rose, there are 2 witnesses for you to cross-examine.
I will do my
30
best.
minutes will be sufficient?
I will do my best given the constraints that we are all operating under, but they are very serious.
Right. So can we give you 1 hour, 15 minutes, and you can share it up between the 2 witnesses?
Yes, please. Thank you.
So that's 2 hours as it is right here, right? And would you all like to make opening addresses? It's not necessary, but if you all would like to, we can have 5 minutes for opening addresses.
I am happy to do a
Dr. Rose?
5-minute open address, but if Mr. Tackleton wants to waive it and we go straight to the evidence, we can do that as well. But I'm happy to do it.
Mr. Tackleton?
I think that's an appeal to equality of arms, so I will waive mine so we could get straight into the evidence so that it doesn't, and we've filed submissions previously in any event, so I have no difficulty with that.
Yes. Thank you very much for your understanding. So we have 3 witnesses today for the applicant, Mr. Russell Dulai. And Mr. Dulai, as he goes first, he can remain. As it relates to Mr. Subaru, and Mr. Rampy. Can I have your assurance that they are not within the hearing of the matter?
They are not in the room, Chair. They are in a separate room, in my office, confined, and then when we need to get them, we'll bring them on. Yes.
Thank you very much. Right, so can we start with the tendering of the first witness
With
for the
your leave,
applicant?
Madam- Yeah, with your leave,
Um,
Madam Chair. Sure. With your leave, Madam Chair, our first witness is Mr. Russell Delay.
Yes, please. One moment, please, Dr. Rose. I wanted to ask Mr. Taklat. I spoke about Mr. Subaru, but Ms. Ravi as well. That applies
Yes.
to Ms. Ravi as well, correct?
Yes, both of them in a separate office, and when we're ready, we'll set up the camera there for them to be cross-examined
Thank
separately.
you very much. Thank you very much.
Can we have an assurance that they are not looking at this on YouTube from a Leonard friend?
I actually just told my junior to ensure that, and he has ensured that there's no YouTube. Yes, correct. Yes.
All right, so they're both in your office in a secure
Yes.
environment. Thank you kindly. You may resume, Dr. Rose. Sorry for the interruption.
The applicant has one witness, Mr. Russell Delay. We filed a witness statement on 20th of April. And if the witness can be shown his witness statement, please, Madam Chair, and his
Yes,
signature.
please. We have it up on the screen. Shortly.
Does
On the last,
the panel do an oath with the witnesses?
yes, we do. Yes, we do.
Okay.
I omitted to request of the doctor who's on the last occasion, but just for the sake of future hearings, to compile a file bundle so to make it easier to find the pages. But it was my omission to ask that you do it. It's not required, but it is usually very helpful at the
Yes.
hearing to locate the pages.
So is it that in terms of process, you would like me to have him certify this, or should he not take the oath before, Madam Chair?
He would take the oath before and then he would certify it. So you're going to listen out, Mr. Dolai, for our hearing secretary who will read out the oath for you and you repeat the oath.
Good morning.
Mr. Dolai,
I didn't hear
I'm
anything.
not hearing you.
I'm not
not here.
hearing anything.
Okay.
Good morning.
I don't believe he's here.
All I heard was good morning.
1 minute. Mr. Dolai, listen up for the oath.
Good morning, Mr. Tulai. Please raise your right hand and repeat after me.
Okay.
I state your name,
I, Russell Dalai,
solemnly swear
solemnly swear
that the evidence
that the evidence
I shall give
I shall give
to the hearing panel
to the hearing panel
in this case
in this case
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Thank you very much, Mr. Dolai. Dr. Rose, he doesn't need to give his address, but he can give his name and his designation.
Good morning. Can you please state for the panel your name and your designation?
Okay. My name is Russell Dalai, and I am the marketing manager at Amalgamated Security Services Limited.
And in respect of the instant proceedings, you signed a statement of truth attached to a witness statement that was submitted to the Office of Procurement Regulator on the 20th of April, 2026. Is that true?
Yes.
If you were to be presented with that statement, you would be able to recognize it?
Yes.
And how would you be able to recognize it?
From both the content as well as my signature.
Right. You see up on the screen your signature at the end of a statement of truth dated on a document that's dated 20th of April, 2026.
Yes.
Is that your signature?
Yes.
Madam Chair, with your leave, I would like to tender this witness for cross-examination using the witness statement that he has just identified as evidence in chief.
Thank you. Any objections, Mr. Takal?
No objections.
Thank you very much, Dr. Rose. Mr. Takal Singh, this is your witness.
Yes. Good morning, Mr. Dalai.
Good morning.
Good morning, sir. Could you speak a little louder? I'm not hearing you fully.
Sure. I'm speaking as close to the microphone.
Perfect. That's good. Mr. Dalai, quickly, you're not a shareholder of Amalgamated, correct?
Correct.
You're not a director, correct?
Correct.
And your authority in these proceedings comes from the board of Amalgamated, correct?
Correct.
And to that end, there was a board minute, correct?
Correct.
And that board minute confined your authority, so to speak, correct?
Yes.
Right. Mr. Dalai, one of the challenges you make in this hearing is a decision by Paria not to disclose certain documents, correct?
Yes.
When was that decision made? Would it be right to say around the 23rd of March?
At the debrief.
Sorry? When was that? When do you say the decision to refuse was made? Was it around the 23rd of March?
Hold on, Mr. Dalai, do you have a document in front of you?
Yes.
Okay, so can you remove it from you're not supposed to, if you need to refer to a document that you filed, you ask the hearing panel and we will put it up on the screen for you to look at.
Okay.
You're not to refer to any notes, any document, any paper, and speak to anyone while you're giving evidence.
Sure. Sorry about that.
Right, Mr. Takla, so you can proceed.
Yes. Yes. So you remember do you remember, would you take it from me? It was on the 23rd of March?
I guess.
Because you had a debriefing meeting, then you wrote a letter, correct?
Correct.
And then there was a response from Paria somewhere on the 23rd or 24th of March. Is that correct?
Yes, but it was at the debriefing I asked for the disclosures.
Right. You asked for the disclosure and you were refused by letter dated the 23rd, correct?
Yes.
Or according to you, they didn't give you all the disclosure on the 23rd, correct?
That's correct.
Right. When was this board meeting authorizing you to challenge these decisions?
It would have been right after.
Right after when?
Right after the
Debriefing meeting?
debriefing, yes.
So the board minute authorizing you to challenge certain decisions was on the 17th of March, correct?
No, it would have been after the
After the
debrief.
decision?
After
Oh,
the
right,
debrief.
correct. And the debriefing meeting was on the 17th of March, correct? You want to see, you want to check your witness statement when you had the debriefing
Yes.
meeting?
Yes, it was after the debriefing meeting.
I could read it for you if you want, and you can take it from me.
Sure.
Sure. There was a debriefing meeting on the 13th of March, correct?
Right.
Right. And then on or about the 17th of March, the debriefing meeting took place. That's at your paragraph 36,
Yes.
correct?
Yes.
You made a request for disclosure and then you followed up with a letter, correct?
Yes.
And then, according to you, Paria wrote you a letter around the 23rd of March and refused to give you disclosure, correct?
Yes.
But when did the board meeting take place authorizing your challenges?
It would be after the debriefing.
Right. So my question to you. On the 23rd of March, you have a decision that you want to challenge, but you got authorization to challenge that decision on the 13th of March, prior to the decision being
I'm
made.
going to object. I'm going to object to this line of questioning. It is unfair to the
Yes, please.
witness. If my learned friend wants to make a submission based on dates that he's seeing in documents, he can do so. He cannot put words into the mouth of this witness. This witness, in
Yeah.
fact, answered counsel and indicated that on the 17th he was refused. And so he knows that on the 7th. This is what the witness said.
No,
Okay,
he said
Mr.
on the 17th
What
to
Mr.
make
Mr.
the request.
Tucker,
Tucker
you're not
sought
going
to do, what Mr.
Mr. Tucker is saying, hold on. Dr. Rose, hold on. Mr. Tucker is saying, do not interrupt your friend. When she's finished, you'll be given an opportunity to respond. Continue, Dr. Rose.
What I'm saying is
Dr.
that
Rose,
the witness is being treated with, oh, is my mic on?
Yeah.
Yes. What I'm saying, please,
Yes, your mic is on.
Madam Chair, is that the witness is being treated with unfairly because the witness attempted his first response to Mr. Taklal Singh was that, no, they refused me on the 17th, which is consistent with his witness statement. But then Mr. Taklal Singh did not get the answer that he wanted. So he says, but it's the 23rd. It's the 23rd that they refused and that you've made the challenge about, right? And I'm saying it is unfair. If Mr. Taklal Singh wants to make a submission about the board resolution having been done on the 17th and the decision being challenged at 23rd, he can make a submission on that and whether there's jurisdiction because of authority, and we will meet that submission squarely based on the evidence before this panel. But it is unfair to harass this witness in this way on this issue of 17th and 23rd and all of that. That is my respectful objection, please.
Thank you, Dr. Rose. Mr. Tucker,
Chair, with all due respect, this is cross-examination. You have a minute on the 17th, which the witness accepted in my run-up and my foundation, gives him the authority to challenge decisions which are before this panel. That decision, he said very clearly, was on the 23rd. He said on the 17th, he made the request. That's what he said, and the panel could play back that. The request, not refusal. There could not have been a refusal because he wrote, and in fact, he has a witness statement. He doesn't say he was refused on the 17th, right? He made the request, and then he wrote a letter, and then a letter was responded to on the 23rd, which refused him. So my question was simply, this is a probity claim. My friend is making probity means lack of morals. I Googled it last night, right? So what my friend is trying to say is that Paria lacks some kind of morals. So I am entitled to test the probity of this action, quite frankly, respectfully. And it's not a long cross-examination. I just want to find out how he got the authority. And it may very well be a part of my submission, but I need to lay the foundation. This panel in preliminary decisions have struck out actions because board minutes were not annexed. And therefore, I'm entitled to probe the probity of the board minute by which they intend to rely for challenging decisions in this matter. And I don't think I've asked any improper question in cross-exam. Inconsistency with a statement and a document is fertile ground for cross-examination, with all due respect.
Yeah. So I would agree with Mr. Tucker's objection overruled. I heard it as a question of the dates of when the request was made and when the actual the 17th be the date when the request was made for the information, the 23rd be the date that the request was refused, and the minutes be the 17th.
Yes.
So you may proceed, Mr. Tackler.
Yes, so Mr. Dalla, you accept there's an inconsistency there,
Yes, hold
correct?
on, before you proceed, Mr. Tackler, your friend has hand up. Yes, Dr. Rose.
Madam Chair, I understand that we are under some time pressure, but I heard it distinctively that this witness said on the 17th he was refused the information. It is also in his witness statement that requests were made for information on the 17th. They were refused, and he was asked to make a formal request after the meeting. They refused to provide him. They did not provide him the information on that day. So it was a continuing refusal, right? So.
Chair, I don't know if Ms. Rose wants to give it.
Mr. Tackler, before you proceed, Dr. Rose, is the witness in the same room as you, or could we ask him to come up?
Yes, please.
Right. So, Mr. Dalai, can you log off and go back into the meeting lobby? We admit you back in.
Well, it's easier for you just to move me back out,
Yeah, true. Yes.
because if I leave, then you'll have to let me back in.
Yes, I'll have it done.
Okay.
Dr. Rose.
Yes, please, Madam Chair.
Yes.
Yeah.
You may proceed. I see your hand up.
Yes. Oh, it's still up. All right. Yes.
You
No,
finished?
what I'm saying is, no,
yeah.
well, I'll just reiterate because the witness has been put out, but I'll just reiterate that it has always been the case of this witness in his witness statement and in the stand. And if there is some, we are not meeting on what the witness just said, then even though we have limited time, I would like us to go back to hear what he said, because as I recall it, he said, I was refused the information on the 17th, which is what he understood it to be. Yes, later on, he then wrote, and then they refused again on the 23rd. But that is the case and what occurred, and which is aligned to the authorities that he got. So.
Yes. So to be clear, you're saying that the witness said he made the application on the 17th, he was refused on the 17th, and he was again refused on the 23rd. That's what you're saying. You recall.
Well, I don't
I see
know if he said
evidence.
again. I
We can
don't
check,
know if he
but
said again. I think there were further questions put to him, and then he said yes on the 23rd. But I know that he said early on, the first response is you made this thing on the 17th, and when he said I was refused on this, I think those words came out of his mouth. At the debrief, he said at the debrief I was refused. Did he not? And then he said he was challenging the refusal from the debrief. He said something to that effect in my recollection.
Right.
And it is then in further questions, he accepted, yes, the 23rd in writing, they did certain things in respect of him. Right. So, but the point that I want to ensure that it's not unclear in the panel's mind who has to rule on this is that on the 17th, there was a refusal. Right. And so.
Okay, so we can check, but we have to stand down to check the recording. Mr. Tackler, say.
Chair, I would just refer the panel and my friend to their grounds of challenge. There's Annex 4, page 6. Appendix 4, page 6. ASSL challenges, as a separate decision, Paria's refusal on the 23rd of March to provide documents and records requested on the 17th of March. That's the ground.
Right. So, okay, Mr. Tackler, I think I understand what Dr. Rosa said, right? So he made a request at the meeting on the 17th. At that meeting, he was told no, so he was denied then. And then there was an email, but there was an email and Paria in email responded on the 26th. So we can check the records, but we need to stand up to check to see what was said.
Chair, I am happy for you to check that subsequent when you're writing your decision. That is not my recollection. That is not any witness statement. That is not any grounds. And that is evidence from Dr. Rose respectfully. That is not what he said. He said requested. I can move on. I think the point is made. I think the panel understands the point I'm making. So I don't need to,
Yes,
there's no jury here. So, right, I think the
Right,
panel
so
understands.
if you're prepared to move on, then we can check it out to do our submissions.
Yes.
Mr. Takman, so you're prepared to move on?
I'm prepared to move on because the grounds are clear and the witness statement is clear.
Thank you very much.
As-
So we will admit the witness back.
We have no idea.
Let's see if I'm seeing him. Mr. Taklan Singh, can you
Yes, Chair.
ask perhaps your co-counsel, Mr. Ramji, or anyone else in the room to contact the witness to join back?
That is, it's not my witness. It might be Dr. Rose that would have to do that.
Sorry. I messed it up. Sorry.
Unfortunately,
Dr. Rose, you're
he's not in this,
Your
we are not
co-counsel.
even in the same country as our witness.
oh, yes, I forgot.
Do we have your permission to text him on WhatsApp or something?
Yes,
to
please,
call him?
we'll appreciate
Thank
it.
you.
Yes. Sorry about the mix.
Yes. We will do it on the record so that you can hear. Russell, you can come back into the room now, please. Yes?
Hi, Mr. Dalai, before you proceed, I forgot to mention it earlier, but on occasions that you're put out of the room, you're not to have any discussion on the evidence with anyone, right?
Right.
Okay, good. So Mr. Takla, so we'll proceed with his cross-examination of you now.
Sure.
Yes. Mr. Dalai, let's just one more on that issue. What time was the debriefing meeting?
But in the morning, I think, if I remember correctly.
Right. And do you know what time the board meeting was?
No. It would have
But
been.
it would have been
after.
Would have been after, yes?
Yes. Yes.
Would it surprise you to know that the board minute authorized you to attend that meeting?
What meeting?
Would it surprise you to know that the board minute giving you authority in this matter, because you've accepted you act with the authority of the board,
Yes.
the board minute authorizing you to attend that debriefing meeting took place at 1 o'clock after the meeting?
Okay.
That doesn't surprise you?
It's a family company.
Oh, I
So-
see. So it's not the board minute that gave you authority. It's the family company scenario.
No, because it's a family company, they can
But-
constitute the board very quickly.
I see. Now, let's move on. Now, one of the issues you have in this case is the cancellation of a July, if I give the exact dates, of a July 2025 tender. And then what you say is a reissuance of an October 2025 retender, correct?
Correct.
Right. you were aware of the cancellation of the July 2025 tender sometime in August last year, correct?
Yes,
A notice of cancellation. You say in your witness statement, you got a notice of cancellation, correct?
I heard about it. I don't remember how.
No, hold on 1 second. 1 second. Let me get your witness statement.
Sure.
2022, you say, and you could correct me.
Right.
A paragraph 2022, you say, I apologize, Chair, 1 second.
Yes, please.
Yes. At paragraph 2022, you say Paria was already in receipt of ASL's complete technical proposal. In or around August 2025, Paria gave notice of the cancellation. We have been unable to find a copy of this notice in our files. So you got notice, correct?
Correct. But
Right.
like I said, I don't remember how it came because I can't find a copy.
All right,
I just
let me
remember
make
that
it-
it was
let me make-
cancelled.
Fine. Let me make it simple for you. You were aware of the cancellation of the July 2025 since August last year, correct?
Yes,
And therefore, and this is why I was asking you about authority, the real reason. And therefore, the company was also aware of the of the cancellation in August last year, correct?
yes.
Did you raise any objection then to the cancellation?
No,
Did you file a challenge proceedings in relation to those cancellation, those proceedings, those procurement proceedings?
no,
In fact, your contract was extended, correct?
correct.
And you accepted the extension, correct?
I'm objecting to this.
Yes.
What contract? There, we are here under CP 2026-4.
Okay.
What contract was extended? Marine, what does it has council confused the matters before?
But maybe the witness is confused as well. Was a contract extended in this work? Was a contract extended in this matter?
To who? Marine, sorry.
Okay.
Mr. Taklal Singh, okay, Mr. Dalai, pause. Mr. Taklal Singh. You can
Yes,
respond to
Chair,
your
I think-
question, but just to clarify, I also need a clarification as to which contract. Is it his work contract or is it the contract with Paria? Just to be
Around that, yeah, let me rephrase the question, right? Around that
clear. Yes,
time,
please.
certain security services contracts were extended. Yes,
Correct.
Mr. Right, and you accepted that, correct?
We were
Right.
we
Hold
were
on. Mr. Taklal Singh, hold on, Mr. Dalai. Mr. Taklal Singh, I know you are on a Miss Dr. Rose, sorry. I know you raised an objection. Are you comfortable with the rephrasing of the question? Because I am not a bit clearer. Did you hear the rephrased question?
I'm sorry,
um,
Madam Chair. The
I
rephrased
can
question
rephrase the question on the contract.
with, I apologize. Can my friend just ask the question again, please?
That's okay. Sir,
yes,
did you receive, or were certain contracts for the provision of security services renewed in relation to Amalgamated around that time as well?
can you please clarify
I'm
which
objecting.
contract you are
I'm
asking
objecting.
about?
All right, not marine, but let's say,
Right, Mr. Dalai, sorry, Mr. Dalai and Mr. Taklal Singh. Hold on 1 minute. Let's. I know we have a time frame, but we still have to make sure everything is done properly. Dr. Rose, I see your hand up for an objection. Can you tell us what your objection is?
Lack of clarity in the question to the witness. We are here on the Marine Security Services contract. If Mr. Taklal Singh wants to ask about notifications in respect of others, where there were renewals in which there may have been interest, he can do so, but he should be specific and guide the witness accordingly and not try to lure
Yes.
the witness into errors.
I said refinery.
Yes.
Refinery,
Mr.
Mr.
Taklal Singh?
Dalai? Yes, the refinery, Mr.
But
Dalai.
no, before, don't answer Mr. Dalai as yet.
Oh.
Mr. Sackler, I want
I
you to
can-
respond to something.
Oh, I can be more specific and say the contract.
Right, so I would also want you to be a bit, I know that it may not be intentional, you're on a roll with your cross, but you, even as it relates to the August, the specification as to whether or not they received notification or the contract was cancelled, you need to be clear when you're asking the witness.
Yes,
So-
okay, yes.
Clark,
So,
right?
so let's be clear. Let's go back a few steps. Mr. Dalai, you accept that you are aware and the company was aware of the cancellation of the tender process around August last year, correct? In this matter.
For which tender? For marine? Yes, for.
Yes, for
the other
marine,
one?
yes.
Right, so this is the one that we're talking about, marine, correct?
Yes, so marine, you
Okay.
are aware of the cancellation of the tender process in August last year, correct?
Yes,
And therefore the company was also aware, correct?
correct,
And you raised no complaint then, correct?
correct,
And you filed no challenge proceedings, correct?
correct.
Good. And when you, subsequent to the cancellation in August of the July tender, you then say you received or you became aware of a new tender process sometime in September last year, correct?
Yes,
Right. And you received those solicitation documents then, correct?
yes,
And you reviewed them, correct?
yes,
And you reviewed them sometime at the end of 2025, correct?
yes,
Let's say around November 2025, I believe you would have reviewed it, correct?
yeah, the deadline was December, if I remember
Right.
correctly.
So somewhere you sat with the July 2025 and the October 2025, and you compared both, correct?
Yes,
Yes? And when you compared both, again, you raised no complaint, correct?
why should I?
Exactly. I agree. No reason to raise complaint. So,
Because this is a new tender.
well, brilliant, excellent. So this is a new tender, and you accepted and participated in the new tender, correct?
Correct, they are the
Yes.
client.
Sorry? Sorry, I didn't
They
hear
are the
that last
client.
one.
They can change the rules as much as they want. They're the client.
Oh, I will quote you on that in my submissions. Yes, they can change the rules anytime you want, right?
Because
So,
they've been unfair a lot of the times. They do whatever they want. They change what they want. They create different things. I'm just looking for fairness. That's all.
okay, and I understand we all want fairness, and you accept that a procuring entity sometimes can make mistakes, yes?
Okay.
Yes, and sometimes the changes may be made, correct? You're an experienced contractor, you're experienced in this. You know, sometimes scopes change, demands change, etc., so that a new process might be embarked on, correct?
If it's transparent, it makes sense.
Fine. Did
But
you ask?
if it's
Fine.
clouded?
Okay, good. When you received the new one in October, did you raise any alarm or write to Paria and say, well, why are you changing this?
We asked for clarification on several things.
Is that in your witness statement that you asked for clarification of why the changes happened?
No, we asked for clarification on their tender.
Right. Okay, good. Yeah. So we're moving on. But in terms of the reissue and the change, you didn't ask for clarification for that, correct?
Correct.
Good. So let's move on to the October. So the October one, you got the solicitation documents, yes?
Yes.
You read them as a good and prudent, informed, reasonably well-informed, diligent tenderer. You read them, correct?
Correct.
And when you read the solicitation documents, you didn't see any issues with them. Correct?
From an operational point of view, no.
Good. So from an operational point of view, when you read the solicitation documents, you saw no issue with them. And in fact, you understand as a reasonably well-informed tenderer, there's a clarification process, correct?
Yes.
Did you raise any clarification issues?
We did.
Right? And those were answered to your satisfaction?
They were answered.
They were answered. Right. Did you go on to raise in your clarification issues anything about lack of sub-criteria, lack of scoring evaluation, lack of matrix, anything like that in your clarification requests?
Remember, we would have been looking at the operational side of it.
That's okay.
We would
Fine.
have.
I see
Okay,
Ms.
Mr.
Rose wants to ask a
1
question.
Yes, please.
I'm objecting to
Councillor
this
Rose?
line of questioning on the basis of what is an issue before this learned panel. This respondent wrote cancelling, accepting and acknowledging that they identified a need to revise the evaluation criteria, the tender documents, to ensure greater clarity, consistency, and alignment with procurement best practices and regulatory requirements. This is not an issue. It is not an issue that on this particular tender exercise, their document did not meet the mark required under the law. That is not an issue. So that I don't know what the badgering of this witness about why you didn't ask questions about the document. I don't know where that is taking them. So I'm
Thank you,
objecting
Dr.
as
Rose.
it being
Mr.
unfair
Patrick?
and it's irrelevant. Yeah.
Yes.
Yeah, with all due respect, perhaps I should lower my tone of voice. With all due respect, firstly, we have raised a clean and clear limitation issue. It is obviously relevant for the limitation issue. The law is, if you want to challenge the terms of the solicitation document, you have to do so within a specific period of time prior to the close of the tender. That's very clear. And I have extracted from him so far that he read it and he understood the solicitation document and raised no complaint there. So that's the first issue why the cross-examination is relevant. And I don't mind if he's here to hear it because he could answer. So I have no difficulty there. The second issue is, my friend said it on 2 occasions this morning, that there are very serious issues here and that she wants a probity, an independent probity officer because there's some lack of probity in Paria. So I am entitled to explore in cross-examination whether or not these errors, which we have accepted there were some errors, and that's why we're going out, were genuine errors that people can make, or was there some scheme that my friend is trying to suggest? She made a comment about handing cookie jar in the CMC. So I'm entitled to ask this witness whether he himself picked up anything that should have been changed, and when did he become aware of the complaints for the purposes of the limitation period. So with respect, I think my cross-examination is very relevant.
Okay, objection overruled. I would agree with Mr. Takla Singh. On the Form 9, the issue of the waiver was in fact raised. And so that is an issue, a matter that we have to return today.
Yes.
So you can continue, Mr. Takla Singh.
Thank you. And Mr. Dalla, if you think I'm badgering you, feel free to tell me. Now, moving on. So we are at the October document. You raised clarification. You didn't raise any issues about criteria, etc. Right? Now, in your witness statement, you do say you noted some material differences. Right? I will read them for you. If you need to look at your witness statement, please don't hesitate to ask. Okay? I'm just for time moving on, and I promise you I'm making an accurate summary. Right? So you say that there were differences between the July and the October. And you have said, well, despite these differences, you didn't raise any complaint at that time in relation to the differences, correct?
Correct.
Good. Now, one of the things you pointed, let's take them very quickly, just because this is part of your complaint. One of the things you say is that there was some increase in the HSE requirements. You remember that?
Yes.
That now, instead of pass-fail, there were 7 items and the scores were given, etc. There was a more detailed breakdown of the HSE, correct?
Yes.
But isn't that, with all due respect, sir, more particulars and better information for you on how to bid and how to satisfy?
It's about compliance.
Right, good. So you've complied. Previously, it was just pass-fail for safety, health and safety, right? And
No,
now
still about compliance, but it's a little bit more
it's a little
detailed.
more,
Yeah,
it's a little more detailed. So the October is more detailed, correct?
on the HSC.
Yes. Do you have any difficulty with more detailed instructions?
No,
Do you have it? I'm sure either you or Amalgamated have no difficulty with Paria improving their health and safety standards, correct?
correct.
Good. You also talk about the splitting up of the marine and terminal in, but is there anything vastly objectionable about that?
Marine was always marine, and we're talking
Sorry.
about marine now, correct?
Right, yeah, sorry. But in your witness statement in this matter, let me just make sure it's 400. Yes, in this matter, right? You do say that there was a splitting up, marine as one tender, terminal and refinery as a combined tender in 2 lots became 3 separate tenders. Yes, in your witness
Yes.
statement.
Yes.
Is there anything objectionable about that?
We wondered why.
You wondered why, but no real complaint, correct?
No, we just thought that they had a preferred supplier.
Did you put that in writing that they had a preferred supplier? Did you write and ask?
I can't write and ask if they have a preferred supplier. They just
You-
throw me out.
Okay, did you ask why? Did you write then, since this is your complaint, then to see if you have a contemporaneous complaint? Did you write and ask them why did you split it?
No,
No, you didn't. Is it that you have a problem now that maybe because you got notice that you lost the contract? Or you may have lost the contract? Is that when the problems arose?
no, it's because we just thought that they had a preferred supplier.
An unexpressed view, correct?
Correct.
And a view upon which you did no action in October, correct?
If we do, we could probably get blacklisted. That's also something that we didn't want to risk.
All right, okay, good. So at the end of the day, for whatever reason, you did nothing. Yeah?
Yes.
Good. You're not afraid you're going to get blacklisted now that you filed 3 challenge proceedings? That has changed?
It
That
is
has
what it
changed?
is.
Okay. I mean, if Ms. Rose was my lawyer, I wouldn't be afraid. But is it that something has changed?
No, what has
No.
changed?
Nothing has changed. Okay, good. Now, another thing you say, I just want to deal with this quickly because in terms of marine, one of your complaints was that the commercial evaluation criteria changed, correct?
Yes.
Right. And it used to be reasonable bid rates, correct? Under
Correct.
July. And then it moved to rates in alignment with industry standards, correct?
That's what they said, yes.
Right, that's what they said. And that was on the, I'm dealing with when you got the document in October, right?
Mhm.
Again, you saw no difficulty with that, correct?
Correct.
Good. Now, I want to read paragraph now, as again, and I'm wrapping up this. You had a July tender with certain requirements. You had a October tender with certain requirements or solicitation documents, and you accept that you, as a reasonably well-informed tenderer, are required to scrutinize those documents, yes?
Yes.
And comply with them, correct?
Correct.
All right. At paragraph 27 of your witness statement, this is what you say. Having recently prepared a compliance submission under the July ITB, which contained a fully populated evaluation framework for the same services from the same procuring entity, ASSL prepared its October submission in the same standard, with a view to meeting each of the evaluation areas that had been identified in the prior exercise. So in other words, you receive an October tender solicitation documents,
Mhm.
right? You recognize, remember I held up the 2 documents, you recognize that there were differences. But here you are in your witness statement saying, well, I don't give a cahoots as to what Paria did, right? I am going to comply with the July tender. Is that what you did?
No.
Let me read it again. This is your witness statement, eh? I assume everything here is true and correct. You just took an oath. ASSL prepared its October submission to the same standard with a view to meeting each of the evaluation areas that had been identified in the prior exercise.
Okay,
The
Mr.
prior
Dalai,
exercise-
hold on. Don't answer yet. Don't answer yet. Dr. Ruth has a hands up.
I would ask that the witness.
I
be
hope
put
no
out.
evidence is going to be given. That's all.
Exactly. You see, I would ask that the witness be put out so that I can make my objection. I don't want to lead the witness.
Yes, please. We will have him. So Dalai, we're going to put you out again. Don't have any conversation about this matter.
Sure.
Mr. Dalai, you have to leave the room, I think. Yeah.
No, we probably put out.
Oh, you can put him. Okay. Thank you, Madam Chair. I'm objecting again on the ground of fairness.
Yes.
Minute from this putting a paragraph that comes after several paragraphs that have identified issues and things that were difficult to follow in certain respects. 26, the paragraph right before, speaks to certain things in the October ITB that were difficult to
Yes.
follow in certain respects. So paragraph
Yes.
27, the witness is attempting to say, well, it was difficult to follow, but this is how we address some of the areas that were unclear to us. And more of that in the submissions will be made in terms of what happened here in respect of this. But I am intervening repeatedly for the witness to be treated fairly, that words are not put into the witness's mouth that the witness has not spoken. So the witness is not saying that all they did was respond only to what was in the July ITB, and to make some sort of narrative around that would be false and unfair to the witness.
Yes.
Right? So the witness is
Yes.
talking, right? So, yeah, that's my
Thank
objection.
you very much, Dr. Ruth. I understand the basis of the objection. Mr. Tackler, your response?
Chair, firstly, the only words I put in the witness's mouth is his own words in 27. And I did preface it by saying if he needs to look at his witness statement, feel free to ask. So he has to be the master of his witness statement. It's not for Ms. Rose to tell him he should look at his witness statement. We're not in a commission of inquiry where I'm just leading a witness. This is cross-examination. I'm entitled to test him, right? And I'm entitled to test his statement and his meaning. And the rule in Brown and Dunn is very clear. I'm being very fair to the witness. I've put my inference and I've said, comment, is that true or not? And he could say whether or not, no, I'm misinterpreting. This is not an ordinary lay witness. This is a senior manager in Amalgamated, one of the biggest corporations in our country. If he feels I'm treating him unfairly, or there's a misrepresentation of his 18-page witness statement, then he can say, and I could be a little slower and let him, and I will ask him. I could ask him that, so I could adjust the question to simply say, I could ask him if he wants to see his witness statement, if that would satisfy Ms. Rose, and we could scroll.
We can pull it up.
But I
Yeah, so
think my
what-
questions
what
are
we can-
perfectly proper. Yes.
Right. Okay, so I would tend to agree with Ms. Rose on this objection because the paragraph before preceding that indicated or listed some of the difficulties in following. The witness, although he may have read his witness statement, may not recall it in the order. So what we can do is we can show the page, which would be page 8 of the witness statement. So you can see the preceding paragraph. You can ask him to have a look at it, and then you can ask your question again.
Sure. Yes,
So,
that's
Ms.
acceptable.
Rose, Dr. Rose, sorry, you'd have to, unfortunately, you'd have to ask him to rejoin because we're not seeing him again.
And when we do it on, I'll do it aloud.
Meanwhile, we'll get the statement up on the screen. So when he comes in.
Thank you. How come it's not coming out? Russell, please come back into the room. Yes? Okay. am I doing here?
Yes, Mr. Dalai, I want to be fair to you. Look at your paragraph 26, look at your paragraph 27. I have two questions for you.
Sure. Uh-huh.
Right. Let me start with paragraph 26, so we're fair to you. Paragraph 26, you say that the October ITB was difficult to follow in certain respects, and you list A to C, correct?
Correct.
Right. First of all, you are aware that it was difficult to follow when you read that document in October or November, correct?
Yes.
You took no action, you wrote no letter, you wrote no clarification requests, correct?
No, we would have asked for clarifications on some items.
On some items, right, not all, correct?
Yes.
Good. Did you ask for clarifications on any of these things in between A to C? I didn't see any clarification requests for matters on A to C. Correct me if I'm wrong.
No.
Good. So you did not ask for clarification for A to C, correct?
Yes.
And then you go on in your witness statement, read paragraph 27 for me. Sorry, I apologize. Chair, could you please pull up greatest of respect paragraph?
Yes, please. Put
That's
it
a
up.
scroll down, yes.
Yes,
Read that
put it up.
quietly for me.
Please
Yes,
see.
so read. Yes, so
Right.
read paragraph 20. Read paragraph 27.
Having recently
You
prepared.
don't have to read it loudly. You can look at it and then I'll ask you the question, right?
Sure. Okay. Okay.
You read it?
Yes.
Good. You accept that that paragraph is saying at the end, ASSL prepared its October submission to the same standard with a view to meeting each of the evaluation areas that had been identified in the prior exercise. So you were focusing on meeting evaluation areas in the prior exercise. That's what it says, correct?
No, it says I am preparing the submission to the same standard. So if I'm at a standard of A, then I would meet a standard of A in the other one. I did not mean that. It doesn't mean that I'm taking all of the information from the prior submission and then putting it into the next submission without.
What does the word prior exercise? What does the phrase prior exercise mean?
The tender that we did in July.
So when you say you were meeting each of the evaluation areas that had been identified in the prior exercise, you didn't mean the prior exercise, you mean the current exercise, the extant.
No.
No,
Okay.
you meant the prior exercise, correct?
What I'm saying is that we
Yes.
would have met the same standard. So we would have put our best foot forward, much the same way we would have done in July.
You put your foot backward, I would say, but you put your foot forward with prior exercise in mind, correct? Let's be neutral, yes?
How could you get that from this?
How could you get that from this? From the language, prior exercise. What does prior mean?
It means
Future?
that, no, prior means that I would have submitted an A quality tender
Right.
in July. And
In the July tender, right?
And I would have prepared an October tender of an A quality as well.
You use the word A quality in this witness statement?
No, but it says here, the same standard.
Same standard as the, why was the July tender relevant? If you got new documents in October, what is the relevance of the July one? Since we want to go there. What is the relevance of the July tender in relation to the October one? Tell me.
I'm objecting, please. Asked
No.
and answered. This is.
Okay, but Mr. Clancy, you can't say no that you my friend can object. Dr. Rose, let me hear you.
He's asking the same question. He's not getting the answer that he wants and asking it again and again. I'm looking at the time. It's 11:31, and I have two witnesses with limited time to ask questions of the witnesses. These are issues that we can submit on in writing. these documents are before the panel. What was changed, what was not changed. This is in evidence before the panel, and we will submit on that. What Mr. Dalai's opinion was on these documents are not going to assist this panel in making the decisions that, in my respectful view, are determinative of the issues before you. So, I mean, it's unfair. Time, having regard to the fact we have all these other matters to deal with, and they are very serious issues. Yes, when I'm cross-examining, we will see, and it may take me some time. So, I mean, he has asked this witness about this. He has gotten his answer. He's not happy with the way the witness is answering about quality, and this is what I meant from this and all of that. Where are we going with this? So I'm objecting. I'm asking that this counsel not repeat and badger the witness with repeated questions in an attempt to get the answer that he wants, which is not even determinative of issues before the panel at this juncture.
Thank you, Dr. Rose. Mr. Takal.
Yeah, Chair, it was I don't know if I have amnesia, but it was a totally different question I asked. What was irrelevant? I didn't ask that before. If you're preparing a tender for October, your complaint is a lack of probity in the October. Yet you have a statement here saying that talking about prior exercise. So I'm asking him, and he says he wanted to meet A standard and A standard. So I'm asking what is the relevance between the July and the October. I'm entitled to probe that. And but I also note, I will take note very carefully of Dr. Rose's opinion, Dr. Rose's objection that the opinion of the witnesses on these documents don't matter. Because I will be raising that objection regularly from the get-go. So I'm happy that that's an objection she could take. So if that is the standard, I'm going to be held to fine. But this was a separate question, and I think I'm entitled to ask it.
Yes. Okay, so Dr. Rose, I would agree with Mr. Takla. I think it's a separate question. It may be on the same issue, but it's a different question. So objection overruled.
Yes. Mr. Dalai.
Yes.
Let me just simplify. In your opinion, was the July tender relevant to the October one?
We wanted to make sure that the quality of response that we had.
You're not answering my question. Yes or no? Was the July tender relevant to the October tender? Yes or no?
There would be some of the same methodologies and some of the same things that would be relevant. Yes.
Right. And therefore, when you say prior exercise here, you were talking about the July exercise, correct?
When I say
where you say prior exercise here, you meant the July exercise, correct? In your witness statement.
Yeah, but what I mean is the quality of the work that we
Okay,
would do.
I didn't ask.
Would be
You
the
could get out
same.
in, Mr. Dalai, you could get out in re-examination. My question was very clear. Right? I'm moving on. Now we move on to the cancellation. When were you informed of the cancellation? Chair, I apologize. How much time? I know I am. I know you're the subject. How much time do I have? I'm happy to be limited. I just want to know how much time I have.
Yes. I omitted to tell you when we started, but you now have about 10 minutes.
So I have about 5 minutes again, is that it? Or 10 minutes?
10 more minutes.
10 more minutes. Okay, good. Cancellation. You were informed of the cancellation around the 27th of March, correct?
Correct.
Yes. And you filed these challenge proceedings on the 26th of March, correct?
Yes.
When you got the cancellation, did you think you should bring it to the attention of the OPR, of the panel?
I'm objecting.
Yes, Dr. Rose. Yes, Dr. Rose, we hear you. Any objection?
Entirely unfair to this witness to ask him about what he needed to bring before the hearing panel. There are certain statutory obligations on Paria in respect of that notice of cancellation. And that is what applies in this situation, please, with respect. And so what Mr. Delay thinks about this cancellation and you know, that it's a question of law that we will be addressing, and Mr. Takral Singh knows very clearly that this is a matter of serious contention that we will be addressing you on in law. In law.
Yes, please.
And we have limited time,
So,
and
Chair.
to just get a star boy moment with a witness that
Chair,
doesn't
limited
not
time,
know the
Chair,
law.
limited, Chair,
I mean,
limited.
where are we going with this? Can
Okay,
we just,
Mr. Takral Singh, let your friend finish. Thank you, Dr. Rose.
I just
Mr. Takral Singh, you could respond now.
Yes, I want to say, first of all, my client is being attacked for lack of disclosure. That's her second out of time decision, right? That's, sorry, Dr. Rose's or the applicants. So there's an allegation of lack of disclosure against my client. That cuts both ways. I'm entitled to probe the conduct of him. And in terms of law, it's very clear. The duty of disclosure 8.1, the duty of disclosure continues until the conclusion of challenge proceedings. So if you have a duty of disclosure, and the duty of disclosure is not necessarily on Dr. Rose, it's on Amalgamated, the participant. So if there was a duty of disclosure and cancellation is relevant, then he had a duty to bring that to the attention of the panel. And I'm simply asking him why he didn't.
no
Probity. This is about probity. Perhaps I should ask for.
I'm
if I could-
objecting again.
you know,
I'm
if I could-
objecting again.
Ma-
It is a question.
Chair, if I
of
could
law.
finish.
Wait, let Dr. Rose, let Mr. Takral Singh finish his submission. Yes, Mr. Takral Singh.
I'm sorry to interrupt Dr. Rose's Stargle movement, but the point is here that he has a duty of disclosure. It's upon him. And therefore, I'm entitled to ask, why didn't he disclose it at the material time prior to a suspension? I have pleaded abuse of process in my Form 9. If this action is an abuse of process because it's meant for some collateral purpose, etc., then I'm entitled to probe the intentions of that. That isn't stargazing. That is real and practical issues which should be interrogated, and I can't see why the witness can't answer. Did he or didn't he think it fit to bring it to the attention of the panel? And this is time wasting. I mean, these are regular questions that are asked in court.
Thank you, Dr. Thank you, Mr. Takral Singh. Dr. Rose.
Yes, Madam Chair, having regard even to what my learned friend just said, putting in the witness's mouth a quotation from the rules, which is false and inaccurate. I'm saying these are questions of law that we should be able to join issue on with you. My learned friend just said to the witness that this witness had an ongoing duty to disclose this cancellation pursuant to Rule 8.1. I'm going to read Rule 8.1 because we can't leave these things hanging out there.
Yeah, that was my response to Dr. Rose. I never said that, put that to the witness. I asked him if he was aware of the cancellation, and did he think fit?
The witness be put out. But if you are quoting the law, I would ask you to quote the law correctly. It is not that a party must disclose all documents that come into their possession. This is not an injunction.
Are we going to oral submission?
Both of you can't speak at the same time.
It is that the person must, the party must disclose all documents on which they wish to rely to prove the case put forward by that party. And both parties have that obligation. Both parties have that obligation. Amalgamated is not relying on the cancellation to prove any aspect of their case. That is the statutory duty of disclosure to which my friend is referring. And it is not fair to cast aspersions on this witness on a misunderstanding and misconstruction of the law. That is what what counsel is doing here, Madam Chair. There is no duty. There is no duty on an applicant to put information before the panel that is not aligned to prove the case put forward by the applicant. It is on the respondent to put all documents before the panel on which it wishes to rely to prove its case. And in fact, this respondent did not even do a Form 9 to put this cancellation lawfully before the panel, and to reverse the burden on this, I think it's
Right.
egregious. I had sight of
Dr.
Melinic and
Rose.
skeletal submissions. Yes, please.
Dr. Rose, I think we are now all getting into our submissions. A lot of this could be saved for submissions. I do accept that it deals with some issue of law and what the witness thinks about the particular disclosure is not necessarily relevant to today's proceeding. But perhaps, Mr. Takla, so I understand what you want to get out, you can rephrase it. We have put the witness out of the room in the meanwhile, but be mindful of the time in that a lot of the stuff you all are saying can be saved for the closing submissions.
Yes, Chair. Chair, I know.
So I understand where both of you all are in terms of it
Chair.
is more issue of the law, but Mr. Taklan saying, I understand what you would like.
Yes. Chair, well, I think they've dropped. Yes,
We are
sorry.
here.
Chair, yes, I'm
Yes.
hearing you know.
Yeah.
You dropped for a second.
Yes. Yes.
Chair, yes, Chair, I understand, and I think you understand the point of the question. I do know
Yes, I
Dr. Rose's submission, and I respect it, that the cancellation is no part of her case. So I assume she's not impeaching the cancellation.
So what we'll do is we bring the witness back in, and Mr. Takla, can you rephrase the question? Mr. Dalai.
Yes.
Yes, Mr. Dalai, you were aware of the cancellation sometime on the 27th of March?
No, we submitted on the 27th. I think it was the 28th.
Okay, the 28th of March, correct? You were aware of the cancellation on the 28th of March, correct?
I think about 4 o'clock in the afternoon, yes.
Okay, all right. So let's say the 29th of March, you became fully aware. You filed this action on the 26th, correct?
Yeah.
Subsequent to the cancellation, did you see it fit? Did you see it fit to disclose the cancellation to the OPR? Yes or no?
No.
No. Okay, good. Chair, if I can have 1 minute to consult with co-counsel.
Yes, please.
In the grounds of repeated cancellation. One final area, Mr. Dalai. When you say in your grounds of challenge, let me just get that quickly. It won't be long. Grounds seem to have us on this one. Yes. 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 When in ground 4, so you remember grounds for your challenge, correct? Mr. Dalai, you remember having grounds of your challenge, yes?
Yes.
And in the grounds, you talk about cancellation, correct?
Uh-huh.
Is it that you have no problem with the cancellation of the July tender?
It was cancelled.
It was cancelled. Okay, good. I have no more questions, Jim.
Thank you very much. Dr. Rose, thank you very much, Mr. Takwalsi. Dr. Rose Cross, any re-examination?
Let me see just very quickly, very quickly. Counsel for the respondent asked you when you became aware of the cancellation, I'm assuming, of this marine. Do you recall counsel asked you that? When you became aware? I'm just asking if you recall that he asked you that.
Yes.
Right. You were unable to provide him with.
He did
Sorry.
provide a date.
Okay. Sure. What are you saying, the on or
So that
around
was it?
August?
Chair, he provided a specific date. He said the 28th.
The 28th?
He said that.
That
He
is
said the
correct.
20th. Yes.
Of what? 20th?
20th of March.
Oh, sorry, I was
Yes.
unclear. I am
March.
unclear. No. So what I was asking about was the cancellation. Council asks you questions around when you were notified of the cancellation relating to the July ITB. You recall you were asked questions around that?
Yes.
And you were unable to, you said that, well, you said you were unable to provide a date about that?
Correct.
Right.
Correct. Yes.
Now, you are involved, Amalgamated was involved at the same time with two other tenders, yes?
Yes.
Those tenders were terminaling security services and refinery and environment security services.
Hold on,
Yeah,
before answering Mr. Dalai. Hold on, Mr. Dalai, stop. Mr. Taklas.
Respectfully, Chair, this is new evidence being given here. She's now leading, sorry, Dr. Rose is now leading the witness along a whole part of evidence that I have not tested. And in any event is irrelevant, as I was stopped for irrelevance speaking about other contracts.
My learned friend.
So,
may I
Mr.
respond before
Taklas,
you
Mr.
rule,
Taklas.
please?
Yes,
Because it
please.
appears if
Yes,
I'm
please.
going on a frolic, but I'm not. My learned friend did ask and did refer the witness to the paragraph 25D, what had been two tenders in July 2025, marine as one tender, terminaling and refining as a combined tender in two lots. He referred to 25D in his cross-examination. He also spoke, so that issue of the two sets of tenders was raised and linked to the notification point. This is what I'm doing right now, where he spoke about notification and asking questions around when you were notified about the cancellation of this tender. And so I'm trying to seek and get clarity around that evidence about when he was notified about cancellation of this tender.
Right. So you can't re-examine on issues that were raised in cross, but it has to be limited to clarify ambiguity. So I'm not sure where the ambiguity lies as to the responses that Mr. Dalai gave on those issues.
Yes, well,
Is it that something?
He was unable to really say how he was notified in respect of marine of the July cancellation. So I'm trying to clarify, yeah, how he would have been notified.
Yes, so that's this. If he's unable to notify, that is distinct from being ambiguous response. So there's nothing that was unclear really.
Well, he said
if he's unable to say, he's unable to say.
But he also
said he could not say. Right. He was notified, but he could not say how because he said he could not locate the document. That's in his witness statement as well.
Yes.
In his witness statement, he said he knew he was notified, but he could not locate the document. And when crossed, he indicated that, well, he could not specify how he was notified because he could not locate the document to prepare the witness statement. So I'm not sure what was the ambiguity that you're re-examining on though.
Because this is the reason why Mr. Taklausing and I had requested that there be joinder and consolidation of these matters, because there may be notification in one of the other tenders where Amalgamated is a incumbent, as they've done in marine. There is clear evidence on the record that they notified marine, they've notified Allied, who was the incumbent on marine, but there's no evidence that they notified anyone else on marine.
Right, but
So,
what I'm
I mean,
saying,
it's
Dr.
about
Rose,
Yes.
is that in his witness statement, I recall, I can look for the exact part, I recall him saying that he could not locate the document.
Para 22.
Yes, so it is not an issue that he couldn't give you an answer. So it's not an issue where he seemed to be unclear as to the question that was asked of him. So I would agree with Mr. Taklal's objection,
Okay.
unless you could point a specific. So is there anything else you want to re-examine on?
Yes, let me attempt with the questions around the board minutes.
Yes, please.
Yes, so Mr. Talkalal Singh spoke to you and questioned you around the when there was this meeting that you were authorized to bring these proceedings, yes?
Yes.
And you gave evidence in respect of that.
Yeah.
Yes? And Mr. Takram Singh sought to suggest that you were not authorized to bring, to query the 23rd, the decision on the 23rd of March. Yes?
Yes.
With your leave, Madam Chair, can the witness be shown the board minute?
No, object.
Well, again, okay, Mr. Taklal Singh, I would hear you, but let me hear you on the objection.
The chair, that's new evidence.
Taklalal Singh?
Excuse me. Chair, that's new evidence. If the witness wanted to see the document, he could have. What my friend wants to do is show him the document to elicit evidence. That's wrong. And as my friend said when I was cross-examining, if she wants to make submissions on the document, it's there. So where are we going in this re-examination?
I can make submissions on the documents in the interest of time,
That's right.
Madam Chair. So I have no further questions on re-examination.
Thank you very much. Right, so Mr. Delay, we are finished with your cross-examination. So you are free to, oh, sorry, I forgot, my panel members have a few questions for you. Fellow panel members.
So, Mr. Dalai, you've been with the ASL since 2020.
Yes.
Is that correct? Okay. And ASL has been an incumbent service provider. I see from your statement from 2023, or does it go further back?
It goes from when Petrotron closed down.
So is that continuous providing of services for how long?
It would have been
You estimate?
either 2018 or 17 when Petrotron closed to now.
Okay. Hold on. Dr. Rose?
With respect, there are three contracts over these three different challenge proceedings. And in the one before this panel, Amalgamated was not the incumbent. So I just want us to be clear on what contract we're asking about and incumbent on what and all of that.
So they were not the incumbent since 2023 because you referred to performance reports from 2023. Is that a different contract you're referring to?
They were not the incumbent on marine, what we're here to deal with.
Okay, so marine contract is was just 1 year, or this is going to be a new contract?
Marine, we did not have in 2023 to now.
Okay. The question I was actually trying to get at is in terms of your tendering with Paria, right? Have you experienced, what has been your experience in terms of the format of procurement? Has it evolved? Have the criteria evolved? I mean, you have reasonable list of rates, you have a structured band methodology. Would you say that it is repetitive every time you have to rebid?
Much of it is, there was one change, which is that, especially in the marine sector more than any of the other, and we're talking marine, in that Paria had actually asked for that the officers be paid a certain value for each of the different services at least. And then they asked for a breakdown of how we arrive at the final price. Yeah.
Okay, and in terms of the technical requirements, is that related to security, to safety, to risk?
Yes, and that's evolved over time. A little bit.
And in preparing, okay, and in preparing your tenders, do you start afresh? Or do you look at, I mean, what I trying to understand from previous exercises, there's standard information that you would refer to in terms of getting submission that you would then amend or clarify to suit a particular tender.
Yeah, that's correct.
Is that fair to say?
Yeah, because if you have to rebuild it, it takes a lot of time, and there are a lot of documents that they ask. So in many of the tender submissions, what we would do is we would have the prior one upgraded, improve as we go along. But yes,
And
there.
in your experience, okay,
Mhm.
thanks. In your experience of submitting bids, what percentage would you say are cancelled? Have been cancelled, just generally, typically?
Very few, very few. There's normally a decision one way or the other.
Okay, so this, it's not a pattern then that your tenders, you submit a tender and it becomes cancelled.
Yeah.
But this particular client, let's go.
With Paria, it's happened twice, and that we've submitted a bid and it's got cancelled, and then we've submitted another one and it's got cancelled, which is unusual.
Okay. 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 I just want, yeah, that's it. Thanks.
Just one question, Mr. Dalai. When did you realize the October ITB documents had issues?
It's as we were going along. So like we would the team who would start working on it would suddenly realize, but wait, no, this is not quite making sense. So we would ask a question on it.
So is it prior to submission or was it in March?
No, we would have submitted, we would have been trying at that point to have limited time to make sure we put the best submission possible. So we would try and do a lot of what we can. You know, because if you don't submit, then you have no opportunity to win the contract. So you would try as best you can, based on what they're asking at the time. But there are challenges with how it was scored as well.
Right. Thank you, Mr. Damai.
Before, Mr. Dalai, I don't think you answered my co-panel member question. Is it in October or is it in March that you discovered the problem? I think I got the answer.
In October, we were just trying to complete the tender, more than anything else.
Thank you very much. So thank you very much, Mr. Dalai. That is the end of your
Sure.
first examination. Yes, Mr. Carlson.
Yeah, I have a question based on a question asked by one of the members that I think needs clarification. Yes. Mr. Dalai, in response to one of the members, you said there were cancellations, which are unusual. Just to be clear, the cancellations you are talking about is one in July, correct?
Yes.
Right, so there was one cancellation in July. And the second cancellation you are talking about is the cancellation which took place after you filed this challenge proceedings, correct?
There's another, I think there was one before as well too.
You have no evidence of that in your witness statement, correct?
Yeah,
You bring no evidence about any other cancellation, correct?
no, that there's just these two so far.
Just
that I
these two,
remember.
yeah, just these two in these proceedings that you're treating with, correct? And
Yeah.
and when you file your challenge proceedings, you were asking for termination of these proceedings, correct? Of these procurement proceedings, not so?
Yes, Mr. Taxas, trying to
Mr.
be
Takwan
clear
Singh,
than-
Well, okay.
Mr. Takwan Singh, you're
Yes,
going
I hear.
further than the clarification.
Okay, much obliged, yes.
Thank you. So, Mr. Delighted, this is the end of your course. And Ms. Dr. Rose, do you have anything based on the course that came out?
No,
The
please,
examination.
no, please.
Thank you very much, Council. So, Mr. Delight, this is the end of your course examination. We would want to take a break here to give a 10-minute break, and we will come back with the order for the disclosure of the redacted documents, and we will proceed with the witnesses for the respondent. So it is now 3 minutes past.
Madam Chair, I'm just wondering about the other matter that starts at 1 p.m. that we have.
Yes.
How is the applicant to cross-examine in the time that we have here?
Well, okay, so we're gonna start, and then we have to push back because the parties are involved in the other matter as well. Right? But we have to deal with the disclosure, your disclosure application before we proceed to the witnesses for the respondent.
Yes, please. Thank you.
And this is why it would have been helpful for us to get the application before today's proceedings, but we will have to collaborate and come up with a response based on what you emailed.
Very well.
So we'll resume at 8 minutes past. Well, please be on time, everyone. Hello? Oh, welcome back, everyone. Having reviewed, you're hearing us?
Yes,
Having
Madam Chair.
reviewed the request for the applicant, it is hereby directed that the evaluation scores of the bidders shall be disclosed with the reduction of information related to the bid prices and the company's estimates and comparison of prices to the company's estimate. This information is contained in the evaluation report, which should also have the evaluation methodology, which should be disclosed. For the PDAC, the same reduction would apply to company's estimate, price, and price comparison.
Yes,
So you got the information?
we got it, Chair. Could it be repeated? You just went in and out there for 1 second. I apologize. I don't want to get it
Sorry
wrong.
about that. Yes. The evaluation scores of the bidders with reduction of the information related to the bid prices, company's estimate, and comparison of the prices to company's estimate.
That would be redacted. Yes, correct.
And for the PDAC,
At the end of it.
Chair,
same
before you go
reduction
on,
will apply.
Chair, just before in the version of the document we have, there's also something called a health check on the document,
Yes.
and that discloses all of the assets of Amalgamated.
Allied.
Of Allied, I apologize. I don't think that's, I think that should be read. I don't think that's necessarily relevant.
We haven't asked for
Agreed.
that.
I think
We haven't
That
asked
is-
for that.
Okay, yes, good.
Yes.
I just it's on the document, so I just want to make sure. Yes, so we'll redact that as
Yes.
well.
yes. And as it relates to the PDAC, the same reduction will apply. So for the PDAC, you will redact the company estimate, the prices, and the price comparison.
And just Chair, apologize, in relation the PDAP document that we have.
The evaluation.
No. Oh, sorry, yes, in the evaluation report, apparently there's a list of employees as well, so we will be reducting that as well.
Yes, you
Yes,
can redact
yes.
the list of employees.
Yes,
as well.
yes, much obliged.
And everything else will stand as it relates to section 52 as stated in the previous order. So, Mr. Takla, I think, could you have that done?
Chair, we're getting that done now.
Immediately?
Yeah, we're getting that
Yes.
done as fast as we can, yes.
Yes. Thank you very much. Dr. Rose, is it that you'd like us to pause to receive it, or would you want us to, or would you be positioned to deal with the witnesses, or would you want to take a break to receive it?
No, in light of the time, I am prepared to start and go forward, and as it comes in, I may ask for, once I know it's in, I may ask for just a couple of minutes to look at it. But
Yes.
I think I'm looking at the time and I'm a little concerned about how we're gonna
Okay.
achieve all
So
that
I
we
know
have
I-
achieved today.
Yes.
Mhm.
So I know I made a point of stressing the statutory time limit, but I don't want us to compromise, the proceedings being done in a fair manner. So in as much as I'm concerned about the time, I still want to be fair to all the parties. Right? So it is now 2:18. Mr. Taklan still wants you to arrange that. We could then
Well-
probably get it with the sort of 12:18, sorry, so not 2:18, 12:18.
5
Right,
minutes.
so we can start at,
Chair, we need 10 minutes to do the computer necessary. Yes, for the disclosure, so that if we wanted to start,
Would
Right.
Mr.
so with that
Takala-
in mind, Dr. Rose, is it that you want to start or you want to pause for the 10 minutes?
What would the panel advise?
Want to be fair to all parties, so if it is you need it for your cross-examination, we can take the pause.
Witness examination, and I would like to ask Mr. Takla saying about the order of the witnesses.
Mr.
one is
Suber, Mr. Suberu is first.
Thank you.
Yes.
Yeah, we can start and press on, and when we get it, I can see what I can do at that stage, please.
Right, so you want to start with Mr. Suberu, and then that you would want to pause during Mr. Suberu's evidence, or is it that?
I would have to, because he was responsible for the commercial, it would so appear.
Chair,
Well,
So
yes.
shall we wait then and? Yeah.
Yes. Mr.
We
Tappan,
will
take your answers up.
so I'm just asking for Mr. Mahes to leave the room permission so that he could go and just sort it out, the necessary that has to be done. Yes?
Right, so if with that being said, perhaps we can pause, I don't know what the other panel members think, but I'm thinking perhaps we can stand down for 10 minutes and resume at 12:30.
Yes, yes.
Grateful.
Yes,
Okay.
thank you.
And chair not to preempt, but perhaps to assure Miss Rose, Dr. Rose, taking the guidance from this order, I will try to for the rest, even though it's not strictly part of these proceedings, I will, so that let's
Yes.
say theoretically it would arise. Yes, much obliged.
Yes.
I'll
Thank
be
you very
grateful
much,
to my
Mr.
friend for that.
Tappan.
Thank you, Mr. Talbot.
Thank you. So we'll resume at 12:30 p.m. Is everyone back? Please turn on your cameras. Dr. Rose, I confirm that you received the documents requested or ordered.
Yeah, I apologize. It's literally going to be sent in 1 minute. I apologize. It's just the reduction took some. Yeah, I really, really apologize. They were trying to work as fast as possible. I believe Mr. Ramkison is actually forwarding it now. Yeah. It's sent now.
Okay, so whilst Dr. Rose, perhaps you can have your co-counsel check on the email. So let's just look at the timing that we're working with going forward. So it's now 12:32 and we have 2 witnesses. We're going to start with Mr. Subaru
Yes.
first.
Yes. Yes.
Does the 1 hour 15 minutes work for you still, Dr. Rose?
I hope so. Yes, please.
We wait on confirmation of receipt of the document.
We can send it can we send a message into the chat here as soon as we receive it? Or
Sure. But can we go ahead and with Mr. Subaru to have him sworn in? Or you would want to wait to have sight of it?
now that
Chair, are you seeing Mr. Subaru? Just double checking.
Yes, we are seeing him in the lobby.
Oh, yeah. Okay. Sorry. All my display isn't showing up. Yes. Okay, good.
Dr. Rose, you were saying?
I would want to wait just a few minutes to have it, please.
Yes. Yes, please. I understand. So we'll stand down for 5 minutes. That will take us to stand down for 5 minutes, perhaps. 12:38, please.
Well, in order to give, oh, has he gone? Okay.
Yes, I'm here.
Chair, in order to give us an opportunity to look at the disclosure when it comes in, let's just, I'm going to ask, can we go to 12:45?
Okay, so 12:40.
Because we don't have it yet.
Oh, no, that
We just received
Fine.
it. So we can, 5 minutes, I can do it. We
Yes,
just
please. 5
received it.
minutes. 5 minutes.
5 minutes. Thank you.
Yes, please. 5 minutes. Hello? Dr. Rose, can you confirm if you got the documents and you had a chance to look at it? At them, sorry.
Yes, we've had the documents and I'm still in the process of looking at it, but we will have to start and we are prepared to start. But we have
But
another
Dr. Rose-
assistant in the room who's going to be running in and out with the printing for us so that I can have it
Yes.
written in printed form in front of me. Please, I'm sharing that with the panel.
Yes, please. So could you put the camera on and perhaps you can have your instructor and your co-counsel assist you with reviewing the documents while we start.
Oh, sorry, I thought my camera was on. Apologies.
Yes.
Madam Chair. Apologies. So you all were just hearing my voice.
Thank you very much. Yes. Thank you very much. So Mr. Taklasing, we have your witness. Is he present?
Yes.
Let's see. Mr. Sheldon Subaru. Is he
Yes,
here
he's
with us?
Yes, he's
Right,
there.
so-
He's on the Subaru, I
Right.
believe it is.
So Mr. Subaru,
Hi, good
you
afternoon.
are going to, good afternoon, you are going to hear the oath from a hearing public panel and you're going to repeat the oath. So let us know if you're not here.
Good day, Mr. Subaru. Please raise your right hand and repeat after me. I state your name,
I, Sheldon Subaru,
do solemnly swear
do solemnly swear
that the evidence
that the evidence
I shall give
I shall give
to the hearing panel
to the hearing panel
in this case
in this case
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Thank you very much. Mr. Taklasing, can you lead him? You didn't have to give his address.
Yes, sir, could you please state your name for your record
I'm Sheldon Subaru.
and your position?
I'm the security lead for Paria Fuel Trading Company.
And you remember giving a witness statement in this matter?
Yes, I do.
And the contents are true and correct?
I believe them to be true and correct.
Okay, check, I tend, is this your, how would you recognize the witness statement if you saw it?
Via my signature, which is present on the document on the screen.
That's your signature?
Yes, it is.
Chair, I asked that the witness statement be tendered and marked.
Yes, you make the statement of Sheldon Subaru will be marked. Sorry, Ms. Dr. Rose, any objections?
No objections.
Good, thank you. So, Mr. Subaru, you'll be questioned by Dr. Rose.
Hi,
Oh.
good afternoon, Mr. Subaru.
Good afternoon, ma'am.
How long have you been working with Paria Fuel Company Limited?
I've been there going on 7 years since July 2019.
And you've been the security lead for the last 7 years?
Correct. Yes, that's correct.
And what are your qualifications and experience?
I have been in the security industry for over 38 years, and I'm the holder of a Master of Defense Studies degree from the Royal Military College of Canada, as well as a Master of Studies degree in Criminology and Police Management from the University of Cambridge, England.
Oh, wow, congratulations, a double master's. Do you
Thank you,
have
ma'am.
any procurement training?
No official procurement training, ma'am.
You would say that you understand the rules and procedures and the guidelines under the new Public Procurement Act?
I'm familiar with the rules and guidelines, ma'am, as it applies. Mhm.
And you did your best to follow them?
Yes, ma'am, I do.
Did you work closely with the named procurement officer on this tender, this 032 Marine Security Services?
With the name procurement officer, not closely, but with the procurement officer assigned to this particular tender.
Oh, who was the procurement officer assigned to this particular tender?
That would be Miss Marissa Rugbeer.
So Marissa Rugby was the procurement officer assigned to this tender. Yes?
Yes, ma'am.
And you and Miss Rugby worked closely on this
That is correct.
marine tender. Now, who is the incumbent supplier on this marine tender?
The marine security tender would be Allied Security.
And that is who was eventually on your evaluation successful in this.
They were the preferred tenderer that was recommended.
Right. And they were the tenderer as well in July when you had gone out. They were the incumbent in July 2025.
That is correct.
And what is your role in the July 2025 tender process?
I, as the technical authority for security services, I would have contributed to the development of the scope of works for the tender, as well as the as well as the evaluation criteria.
That was all that you did in respect of the July tender?
As well as the company estimate.
That's all that you did in respect of the July tender?
I was involved subsequent to the issuance of the tender with providing guidance in the mandatory virtual meeting, as well as the subsequent evaluation of the tenders.
We'll get to that. What was the reason for the cancellation of that process?
For the July tender,
Yes.
during the evaluation process, there was a technical issue with the e-box tender platform, which caused commercial lump sum information, the value of the commercial information to become visible prior to the completion of the upload of the technical evaluation scoring.
Were you in the, well, let's just see that we get that clear. You are saying that the reason for the cancellation was that the lump sum pricing became visible, you said?
Visible on the platform.
On the platform. Right. Now, so were you in that debriefing meeting on the 17th of March when Mr. Russell Dalai asked you, were you in that meeting? Sorry?
Yes, I was.
Right. You recall Mr. Russell Dalai asking you what was the reason for the cancellation of the July tenders?
Yes, I recall him asking.
And who responded to that question?
I can't recall exactly who responded. I think it might have been Ms. Rugbeer.
Ms. Rugbeer. All right. And what was the response that was given?
I believe it was that there were technical issues with the platform before the technical evaluation scores were uploaded.
Sorry?
And before the technical evaluation scores were uploaded, which compromised the process.
This is what you heard Marissa Rugbeer say on March 17th?
Not in such detail.
Oh, so I just want to know what was told to Mr. Russell Dalai on the 17th of March 2026 as the reason for the cancellation of these tenders, sir?
I can't recall the exact words that were used, but it was related to the technical glitch or technical issue.
Now, who else was in that room?
This was a virtual meeting.
Yes. On your side, who was in that room?
In addition to Mrs. Rugby and myself on the Paria side, we had Mr. Mahendra Mahes, the name procurement officer, and a number of representatives from the Amalgamated team.
Oh, so there were a lot of people in that room?
Based on the introductions that were done, yes.
Based on the introductions, there were a lot of people in that room? One minute. Now, sir, is it not true to say that at that debriefing meeting, what was said by a male speaker was that there was a technical issue and there was a problem with accessing the submissions?
I can't recall exactly, no, ma'am.
So it could have been said?
It could have been said, but I can't recall exactly.
So if you were to hear a recording of the debriefing meeting, you would be able to recognize if that is what was said at the meeting in your presence?
I should be able to recognize it, yes.
Now, how many people spoke in that meeting from your end? Because you're now saying there were a lot of people in the room. How many people spoke?
From the Paria side, 3 persons were involved in the conversation.
Who were the 3?
Myself, Mrs. Ragbir, and Mr. Mahes.
You did not answer any question about the problem with accessing the submissions, about the reason for the cancellation, did you?
No, ma'am, I don't think I did.
You thought it was Miss Ragbir who did so?
I generally cannot recall who would have made the comment. Don't even recall whether it was a male or female voice that made the comment.
With your leave, Madam Chair, attached
Yes,
to,
please.
we have put into evidence the audio recording of the debriefing,
Yes.
to which there has been no objection.
Yes.
Has the panel been able to access the audio recording?
Yeah.
So I am going to ask that a portion of the recording be played for this witness to give his recollection of the comments made in respect
Are
to
you
the
positioned
reason.
to tell us the time?
Yes, we can tell you the time. At 5:57, 5 minutes and 57 seconds in to the recording. Now, while we are trying to access it, I will continue.
Sorry. Chair, are we playing the recording or I missed that part. Are we going to?
Please,
I'm applying for the audio to be played to this witness.
Well, let's play the audio. Chair, could I be permitted to leave the room for just 1 minute? And I'll be back shortly.
Oh.
Yes.
I'm assuming we'll wait for Mr. Taklausing to return, Madam Chair.
Madam Panel Chair, I could the recording could go ahead, please. I can handle it while we go now.
Okay.
Only recording. Are we? Yeah. Yes. We will play the recording shortly.
Do you wish me to go ahead with some questions until that is queued up, Madam Chair, or we'll wait?
If depends.
I'm happy to go on while we wait for it because I'm mindful of the time. Yes, but I do want it played.
Yes, you may proceed.
Thank you.
Yes.
Let's go back to the procurement training point that I had asked you about your procurement training. You said you didn't have any. That's correct?
That's correct.
How many of these exercises had you been involved in?
I would say all of the procurement for the security services since I've been part of Paria.
So that's about 7 years you had said. Am I
That's
correct on that? And all would be how many?
I would say approximately five exercises.
Okay. And you were involved in procurement exercises in other positions that you held before?
Outside of Paria, yes.
Yes.
Yeah.
Okay, and you took lead on this one. Is that correct?
Well, as the technical authority, I hold certain responsibilities in respect to those particular procurements for security services.
So did you take lead on this?
Yes, yes.
And in your work, in your functions, in your position as lead of security, you work closely with the suppliers?
Yes, we do.
You manage and oversee the suppliers?
Yes, I'm responsible for contract management.
For contract management. And that would entail interactions on a monthly basis, weekly basis, daily basis, hourly basis, what?
We will have contract review on a quarterly basis. We'll have meetings sometimes on a monthly basis or on a need basis, depending on what is happening.
On a need basis, depending on what is happening.
Correct.
Right. And you would say,
Dr. Ross?
yes?
Sorry to interrupt you, but we seem to be having a bit of a difficulty with the audio. So if you are in position, perhaps you can ask your co-counsel to organize it and you can play it on your end. So in the meanwhile, while you continue to your questions, it will be organized. So when you are ready, you can play.
Yes, we'll try to do so.
Chair,
Apologies.
Chair, I just wanted to add that we
Yes,
also had I just want to add we also had difficulty accessing the audio.
It was on the secure platform.
It seems to be that it's on an amalgamated secured platform with you need amalgamated credentials to access it. So that might be the issue that you're also having.
No, we provided the access credentials to all the email addresses associated with this hearing, please.
we got the access credentials. That is not our problem, but I understand.
Thanks.
Well, the audio is not the best, so we're going to have to strain a little bit to hear. And
Yes, please.
that's, although, you know, it was a Microsoft Teams meeting. While you're trying to, right, so yes, so you were managing, you were having interactions. You would say Allied, who was the incumbent, was doing a good job for you?
Allied was the incumbent for the Marine Security Services. Sorry,
Allied
my
was-
apologies. Yes, Allied was the incumbent, and yes, they were performing satisfactorily.
Right. You would accept. I'm trying to understand your level of understanding of procurement rules and all that sort of thing. What would you say a debriefing exercise is about? Because you were there, you took lead of this process, you were there, and then you also came and participated in this debriefing exercise on the 17th. What's the purpose of it?
My understanding of it, and this is relatively new, because we haven't been using the debriefing exercises prior to that tender in July, is that it gives feedback to the supplier on issues related to the submissions and the evaluation of those submissions.
Right. And so you come to that meeting. What would you expect to have to hand in a debriefing meeting where a supplier wants to understand why he received the scores in which he did? What would you expect to have in your hand?
Information related to the specific tender
And to the supplier,
and
yes?
related to the specific supplier as well.
And his scores.
And his,
And their scores.
and I assume yes, we will have that information available.
But you didn't, did you?
The information was available, yes.
The scores of Amalgamated, the breakdown of Amalgamated scores were available on the 17th of March, 2026.
It was available during the debriefing conference.
Also, it was available but withheld.
The information was not shared as we weren't sure that was information that could have been dispersed at that point in time.
Hold on. You're saying now, because there are several steps here, you are saying that Amalgamated came to a debriefing to understand why they were not successful with it. You understood that that was the purpose,
No,
yes?
no, I object. I object.
Yes, Mr. Taklansi.
Yeah, sorry, I wasn't
Mr.
sure if you were
Taklansi.
seeing me. Yes.
Sorry
Yeah.
about that.
It's unfair to ask the witness what Amalgamated thought they were coming there to do. That's a wholly improper question. With all due respect to my
I
friend.
thought we had established it, that he had said before that what the purpose of the debriefing meeting was.
So that's different. That might be his understanding.
I can
Yeah.
rephrase if that
Okay.
would assist my friend.
Yes, please, rephrase Dr. Rose.
Yes. So you understood that the purpose of that debriefing was to give Amalgamated information on why they made the decisions that were made in the way in which they were made. Yes?
Yes.
And you understood that the purpose of the debriefing was to ensure that Amalgamated understood why they got the scores they got.
Yes, yes, that was my understanding.
Right. And so would you not accept that you ought to have come prepared and have it in your hand, this breakdown of Amalgamated scores? I'm not talking about any other bidders, but the breakdown of Amalgamated Securities scores on the marine tender.
Yes, and it was my misunderstanding of the question just now,
Ah,
right? Because we did have those scores available,
Amalgamated scores, yes.
correct? And those scores were provided to Amalgamated prior to that meeting. with the notification of award letter.
And the full breakdown. The
The
full
breakdown of
the
this,
scores?
well, the breakdown of the scores, yes.
And you were in your witness statement, you spoke about compiling the scope of work.
Correct,
Correct?
yes.
What do you mean by compiling the scope of work?
So the scope of work will describe exactly what type of services that we require, that the bidders will tender on. I would be responsible for giving the specific descriptions of those works and the quantities of the different services that we require.
So who else helped you to compile the scope of works?
It was primarily myself.
Primarily, well, who was it?
It
Who
was
else?
myself, yes.
Also, you developed the scope of works.
Correct, yes.
You were also responsible for the developing the scope of works in the July tenders?
Yes, I was. Yes.
And you said the reason for the cancellation was because the lump sum pricing became visible on the e-box platform, something to that effect?
That will be the July tender, yes.
And this was after you all had opened all the technical submissions, correct?
That is correct.
And it was after you had actually done a technical evaluation. You had completed a technical evaluation in July, had you not?
We did complete the technical evaluation.
You did complete the technical evaluation. And then you chose to cancel the July tenders, correct? Because you say you saw the lump sum pricing visible on the platform.
Yes, it was visible prior to the completion of the upload of the technical scores.
So it's not true to say that you canceled these tenders because you were not able to extract the submissions.
Can you repeat the question?
So it would not be true to say that you canceled the July tender because you were not able to extract the submissions. That would not be true.
No, it would not be true.
And if anybody said that, it would be a lie.
It would not be true, no.
Not be true. Because you had full sight of the submissions and you evaluated the submissions. Yes?
Yes.
Now, did you communicate to the tenders on this marine tender that you were canceling that tender?
No, I did not.
Did anyone do that?
I am unable to say if anyone was contacted or communicated with respect to the reason for the cancellation.
That's fair because you haven't disclosed any notice of cancellation to any tenders in the July tender. Is that correct?
Before you answer, Mr. Subaru, I see an objection from Mr. Takal. So his hand is up actually. Mr. Takal,
A cancellation note was disclosed.
Mr. Takal, what is your objection? Is it that you objected?
I have no citation.
Yeah. Yes, I'm objecting because it's an unfair question. This witness
Right,
may not know. Yes, we can ask him to leave if that would be more comfortable.
I'm happy to continue.
Yeah. Well,
Yeah,
the
you can-
objection is my friend is asking an unfair question because you say that it was, but disclosure is done as a process for the court. So I'm saying that a cancellation note for the July tender was indeed this very voluminous disclosure bundle. Perhaps my friend missed it, but
It
it's
was
there.
not.
It is
I
there.
have not seen that, so I don't know if the council is
Well, we
giving
could pull up the
evidence
disclosure
regard to
bundle and I could bring it to your attention.
Well,
Okay.
then we can do
So
that during
Dr. Singh
submission. Yeah.
and Dr. Rose, one at a time.
Sorry, I
Dr.
apologize.
Thank you, Mr. Taklalsing. Well, it was Dr. Rose interrupting you. Dr. Rose, let me hear you now. I wasn't hearing you clearly.
Well,
You heard your friend? He indicated that there's a cancellation note. Your question is unfair. Is it that
to the
you said you
bidders,
want
to
to
the
proceed?
bidders, there's no such disclosure to the bidders, no, on the marine. If Leonard Friend would like to point me to it, I'm happy to.
It is, but there's no trial bundle, unfortunately, but it bears the stamp Office of Procurement Regulator, and it was in the disclosure bundle. It's dated 26 September. It has a summary of recommendation. It has the full reason as to why the July
That's a summary of recommendation. That's an internal document.
okay, well, you
Summary
said this.
of
You said I assume you. Sorry, I don't mean to converse with Dr. Rose over you, Chair.
Yes.
But this was in the disclosure bundle in these proceedings. That's what I'm saying.
But that's
So
not a notice to the bidders.
Right.
That's not
Please
the-
allow me to. Okay.
That's not the question. So I apologize. I thought the question was it
Mr.
disclosed?
Mr. Taklalsing, let Dr. Rose speak now. Dr. Rose?
Yeah, it's
Okay.
not whether their internal decision was disclosed in a bundle in the course of these challenge proceedings. I am asking him contemporaneously and in accordance with the requirements of the Public Procurement and Disposal of Public Property Act, whether notice of cancellation was given to the bidders, for example, Amalgamated, who participated in this exercise, that this exercise was being cancelled.
Thank you, Dr. Rose. Objection overruled. Yes, Mr. Taklalsing. I understand what Dr. Rose wants, and it is very distinct from what you're asking about. So objection overruled.
Okay.
Is it something else you wanted to add?
Yeah, yes. Well, let the question be answered. I don't want to waste time. Not sure.
Yes.
And he said
Dr. Rose?
the witness answered it, but Mr. Taklalsing then said, no, that's not true because the witness said no. He does not know
Well, he did not.
if any notice was given. The witness said that, and Mr. Taklalsing then objected to say, no, notice was given and that disclosure was made to my learned friend. That's what we've just
Okay, I
engaged in.
understand, Dr. Rose. Can you answer your question so you can get it for the record?
Yes, in respect of this marine tender, you took the decision to cancel the July tender process after you had access to all the bidders' technical submissions, commercial pricing submissions. After you had done an evaluation of it, you took a decision to cancel. Did you notify the bidders in marine that you took the decision to cancel?
I am unable to say whether a notification was sent to the bidders. I am not involved in that part of the process, but I would have been involved in the recommendation to cancel, which would have been an internal decision.
Right.
Excuse me.
So can we play so let's go to that debriefing where you said you are saying the reason for the cancellation was lump sum pricing being made visible on the eBooks platform, and this was after you all had done the technical evaluation. So my goodness, this is very problematic for you all. So that is why you canceled the process.
Is that a question, Dr. Rose?
No, I'm just recounting what he has said, and my learned colleague is going to now attempt to play. Ms. Smith has indicated she will have to drop off in order for it.
Yes, that's fine.
Let's see if it is really soft, but
Yeah, Dr. Rose, we have actually now sorted it out.
so you can do that.
So we can play, yes.
Let's try here if we can hear it better from yours, because And if the volume could be at the highest, please, because this was not in the Microsoft Teams. This was on a device on the table.
The time is 5 minutes and 57 seconds.
5:57. There's a male voice speaking. I don't know who it is. It clearly it's not Mr. Subaru, but perhaps it's Mr. Mahis.
Yes.
So you're ready? Good begin? Yeah. So the purpose of this meeting is that Amalgamated would have requested a little briefing with respect to the provision of security services. These contracts would have been for the refinery and environments, terminal and the marine area. So based on our request, more specifically, we would like for you all to just maybe go through the items for discussion.
Sure. Okay. All right. So we had tendered for something similar a couple of months before in July.
Dr. Rose?
I was just saying we'll have to listen to 5 minutes and 57 seconds, and if we take it from the beginning, but if we go to 5, I'm happy to play the whole thing. But we have a time constraint. So if we go to 5.
Yes, we want to start.
Okay. 5. Yeah, let's just stop there because that will lead us into 5 to 5.7. So let's see what's here.
Right.
Last year, the refinery and the terminal facilities were lumped in the lots of one and the marine was distributed separately. But because of the issues that we faced with that particular arrangement, because what we saw is that vendors and people the submissions we had to cancel, and then we decided to report back to the student and separately any subsequent one. But then we had technical issues with the e-books. It was a problem with accessing the submissions. So that was something we had.
Okay.
And then this one issue.
But did you notify the tenderers about that? Because I didn't get any notification. All we got was just that it was cancelled.
Yes, we can send something saying that we cancel and we normally don't put in details, the cancellation notice unless a very specific.
Is that sufficient, Dr. Rose, or do we need to go
Well,
further?
on that point of cancellation, yes. This whole thing is tendered into evidence, and I hope that before a decision is made, that the whole thing will be listened to. But did you hear that, Mr. Subero?
Sorry, I didn't hear clearly the comment that was being made on the other side.
On the other side, but did you hear a male voice speaking?
Yes.
On Paria's side, did you hear that?
Yes.
Whose voice was that?
That was me.
That was you speaking?
I want to believe so, yes.
Well, on the recording, did you hear that male voice saying that we were not able to there was a technical issue and there was a problem with accessing the submissions?
Yes, I believe that is what I heard, but it was not referring to the technical submission in terms of downloading of the technical submissions. It was when we were trying to upload the technical evaluations.
So you had a problem accessing the submissions?
The issue was the commercial information was visible when we were attempting to upload the technical
Right,
assessment.
so that you would accept, those are two different reasons for cancellation that you're providing here. Would you accept that? One is you got all the information and you actually got too much. You got too much in the wrong time. You got everything and too much in the wrong time. So that's why you canceled. And that's what you are saying today in evidence is why you canceled.
That's not what you.
No, sorry.
Yeah, Mr. Takalse, you objected?
But I was going to object to say, but the witness has answered, so he could explain. But that's not what he said. So
My apologies if I'm mischaracterizing what the witness said. Did you not say that the reason for the cancellation was that the lump sum price was visible?
That is correct.
On the e-box thing. So you got information, right? At a time when the technical evaluations were underway and now completed. Yes?
Correct. Yes.
And so you got all of the bidders' information. Is that correct?
The technical submissions information were available to us. The commercial lump sum became visible when we were uploading the technical assessment. We were trying to explain during the debriefing that because of technical issues, with that tender had to be canceled.
Yeah, no, don't try. You're trying. I hear what you're attempting to say today, but you just heard the recording, correct?
Yes, ma'am.
And in the recording, that voice, who you have now identified as you yourself, you
Yes.
said that there was a problem with accessing the submissions. That was pretty clear on the record.
I believe my explanation wasn't clear at that time.
Oh. Okay. Okay. So you were responsible for compiling the state of works, the scope of works in July. You were responsible for doing the scope of works in October, yes?
That is correct.
And it was cancelled. We just went at length. It was cancelled for these technical reasons, correct?
Correct.
Now, if after having evaluated technical submissions and seen vendors' pricing and all of that, you decided, an entity decided to cancel a process and then change the evaluation criteria, would you say that that's a correct thing to do? Trying to understand your knowledge of process and all that. What?
Oh, hold on, don't answer it, Mr. Super, Mr.
yes.
Takalse.
Well, I am objecting. His opinion on whether it's a correct thing to do is irrelevant. That is with the panel to determine whether the only material question is whether it is lawful. Well, first of all, it's not an issue that arises in these proceedings because there's no challenge to the cancellation and that's limitation period has gone. So, but that aside, even if you wanted to challenge it, his opinion is irrelevant. What are you asking? His opinion, whether it was the correct what? Morally, spiritually, or legally? The only relevant question here is whether it's legal or not, and that is a question respectfully for the panel to answer.
Dr. Rose?
Leonard Fred keeps mischaracterizing the challenge before the current hearing panel. We are not in any way at this stage, we are time barred. We are not challenging the decision in July. We cannot. We are time barred. We are looking at the historical conduct of this particular tender process, and we are identifying issues that speak to breaches of Section 5 of the Act. If certain, they have said we are alleging malintent. That was in somewhere in those submissions that Mr. Taklal Singh has provided. There may be. We are trying to see whether in the decision to reissue with different criteria, whether there is malintent. So I am actually asking, and this is something that is before the panel, because if in the October reissue, there are issues around what they were attempting to achieve, if there was any attempt to manipulate a process in order to favor another contractor, then this is quite correctly before the purview of this panel. And the relationship between the July tender and the October tender speaks to that process. I see Melinda's friend's hand is up.
Yes, Mr. Taklal.
Chair, is it any part of the grounds and allegation that we were favoring a particular contractor? No part of the grounds,
okay,
no part of the relief,
Ground
no
four
part of.
speaks- Okay.
So, okay,
Madam Chair, can I say this? Can I say this?
yes.
An applicant, a challenger who brings a challenge cannot know or understand why certain breaches of the Act occurred. What we did do, because of certain information that we had in our possession in respect of the ITBs, is that we said there are questions to be answered in respect of the cancellation and reissue of these tender proceedings. And I would say that having had some of the disclosures that we now have, we are in a better position to question these witnesses without saying more at this stage with the witness here, on their motivations with respect to this October tender that is before the panel.
Okay, so,
If I could just quickly respond. Quickly respond. Yeah, it's about fairness. You have to go on what's in your grounds and what's in your claim form or your form 8.
Our grounds are there. The ground
Well,
cancellation and
so-
reissue raising issues relating to the fairness, accountability, and transparency of the process.
But that has nothing to do with
Right, so thank
favoring.
you, Dr. Rose and Mr. Taklal Singh. I have to agree, Dr. Rose. I understand that it's a different cancellation. However, it speaks to the circumstances leading up to the cancellation. And it is in fact part of the grounds and part of the gist of one of our grounds. I couldn't find the exact part,
Ground
but
four.
I would, yes, I would overrule the objection. Ms. Rose, you may proceed.
Thank you.
Dr. Rose, sorry. The last one, sorry, 4 indeed.
Right. So I have actually lost where I'm at, Madam Chair, with this objection. Was I
Right,
dealing
so
with
first, put your hand down so I know when you actually raise your hand.
Sorry.
And, right, so you were asking him if he felt it was fair to cancel along the line.
Right. No. I was asking him about his understanding of what is appropriate
Oh, yes.
in terms
Yes,
of
appropriate.
cancellation. Thank you, Madam Chair. You would accept that to cancel a tender after evaluating tenders and seeing all of the submissions, technical and commercial, and then changing the evaluation criteria in a subsequent reissue raises concerns about the process. Would you accept that?
No, I wouldn't.
Okay. Now you indicated that, so you don't see anything wrong with canceling a tender because you say there was a technical issue with respect to accessing submissions. Now you're saying you had them, but that's what you said. And then materially changing the terms of the tender, you don't see a problem with that?
Because I'm aware of the circumstance, I would say no, there wasn't a problem with it.
Well, tell us, help the panel and help us with the circumstance, because there were material. Can my co-counsel be let back into the room, please?
Oh,
She came off to play the recording and then she was never let back in.
Yes.
Apologies. But she's right
Sorry.
here at my side. Yeah.
right. So Dr. Rose, we have reached 45 minutes in a cross-examination. So how long again do you have?
Points of time. Sorry. Let me get I would like to go into the changes now, please,
Yes.
Madam Chair. So I still need some time with this witness. Okay. So do you recall, well, you were telling us the circumstances of the changes that you made?
Okay, so having completed the technical evaluation in the July tender, we observed that some bidders had issues with the requirements of the tender because they were done in lots. So they commingled information. And what we sought to do is improve the clarity on the subsequent tender. So we separated the two that was issued in lots in July and issued.
Well, Mr. Sabero, Marine was one tender. Yes?
Yes,
It was one tender in July
correct.
and it is one tender in October. Is that correct?
That is correct. But what I'm seeking to explain is that the same issue we experienced with those other two tenders we experienced with the Marine, which is the commercial information, the commercial lump sum information became visible on the platform. So we opted or recommended to cancel that entire process.
Okay, good. I think we've all heard that explanation repeatedly. I'm talking now about the changes that were made, because if that is the reason why you're canceling the tender, right? There's no reason.
1 minute, Dr. Rose.
Chair, my learned friend needs to be clear on which change she's putting to him, because I think she's saying changes, but we have 3 contracts, different changes. If she could put a specific change that she wants an answer, I think that's the best way to go ahead.
I have not put the change yet.
Okay, sure.
I have not put the changes. I'm asking him about changes and whether changes were made.
Yes.
Yes.
Dr.
he
Rose, we're
said
not
yes.
saying your co-counsel is not in the room.
Maybe on the wrong link.
Remember earlier we had a problem with the correct link, so make sure it's the correct link. So you can proceed to.
Yes, but just to say that she is in the room with me, but
Yes,
she was on another computer. Yeah.
She's not in the lobby, I should say, not in the.
Okay. Yeah, so you are saying, and I'm tired of belaboring this now, and I know you must be tired too, Mr. Subero, right? Going over this, but your counsel keeps objecting. So you canceled because the pricing was available, right?
The lump sum values, yes.
And I am saying, I asked you whether you think it's appropriate after seeing these tender evaluation, tender documents, doing a technical evaluation, and then also seeing the commercial pricing, to cancel and then reissue with material changes. And you said you saw no problem with that.
That's correct.
Remember you said that you saw no problem with that. Even in the circumstances of saying the reason you canceled was technical, correct?
That's correct.
And you saw no problem with that.
That's correct.
Yes, and
yes,
you
I
said
agree with you.
in the circumstances of the case, yes, that could happen. You said something to that effect, yes?
Yes.
And so, yeah, I'm just asking, so what would have given rise to changes between the July marine tender and the October marine tender? having regard to the fact that you canceled it because of a technical issue. You made changes, did you not, to the technical evaluation criteria? Did you?
For the marine security?
Yes.
Not that I could recall. Not for the marine security.
Not for the marine. So the marine security, there were no changes to that tender?
Well, in fact, yes, there were. Now that I cast my mind back to it, there would have been more requirements in the management systems section of the submissions.
All right. Is there anywhere that there would have been less requirements?
I'm unable to say right now. I don't have the documents before me, or or anything to refer to.
I hear you, and I will put it before you. But you were the lead on this. You said that.
That's
right?
correct.
And you would understand that canceling for a technical issue and then taking the decision to make changes to the evaluation criteria, that's a pretty important decision to have made. Would you not say? You think that's routine?
It's not routine. It's an important decision.
Right. So that is something that you would remember. You made changes to the marine tender, not so?
Well, there was an opportunity to review the what was being asked of some bidders, and as well as how it is being evaluated. So amendments would have been made, not based on what was seen in terms of the submissions of tenderers, but in terms of how we represent what is required and how we evaluate it.
Okay, so let's just say hypothetically in the marine tender, for example, that you required all contractors to have all their officers to be fluent in English, right? Let's say that was there. And then in the October tender, you remove that. You think that is appropriate? Having seen the documents that they have,
Dr. Rose, we don't want to ask the witness to speculate. Can you just
I am not asking the witness to speculate, Madam Chair. I'm asking the witness to understand what he thinks is appropriate, and then I'm laying my foundation, and then I'm going to put certain
But Dr. Rose, that is not evidence in this matter, though. If
What is not evidence, Madam Chair?
What you just said, you asked, well, first of all, you asked a question on a specific point already, and then you asked them, supposing they were supposed to be fluent in English. Is that part of this? Is that part of the evidence?
Can the witness be put out of the room if we are going to go here, please, Madam Chair, if I'm to respond fulsomely?
No.
Chair, let me how we do now?
Mr. Sibaru, you would be put out of the room, you know, to speak with anyone on this matter.
Yes, ma'am.
You have to log back in to get back in.
Okay, ma'am.
Chair, I'll just have him leave the physical room and go to the kitchen area and then call him back. That might be easier than mute and unmute.
He's in the same room as you?
No, he's not in the same room. He's in my office, a separate office. So I'll just have someone, he's by himself in a separate office.
Okay,
so I'm just going to ask
him in a waiting room.
Put him in the waiting room.
Yes, we put him in.
Put him in the waiting room.
No, we are off.
Oh, I understand. You put him in the virtual waiting room.
Yes, virtual room. Sorry about that. Yes, Dr. Rose. So, Dr. Rose, what I heard you say, he's sorry.
Madam
No, he doesn't have to leave, Mr.
Yeah, let me just clarify one second. Mr. Figueroa.
Are we putting him out in a room?
You can stay.
Yeah,
sorry. I apologize.
Right. Dr. Rose.
But that's in here.
Yes, Madam Chair.
I think he's waiting to be put in the virtual waiting room, Madam Chair.
Yes, you're supposed to put him in a virtual waiting room.
And sit down, tell him.
He has to accept to go. So we're asking him to go into the virtual room and he has to accept to go.
Oh, yes, acceptable. Let's show you that.
You're
Chair, you
supposed
was
to see, accept.
Yes. I apologize. The Apple, he doesn't know how to use the Apple computer I'm having it. So we're just gonna get done for him.
I understand.
I have to accept something to when you go to your waiting room.
Yes, you should see it across the screen.
No, it doesn't. It's not appearing across the screen. There isn't a prompt there. Yeah.
Right. Right. So, Dr. Rose, what I understood you to be asking is if there's a requirement that the officers be fluent in English. Your use of if it was required, I get the impression, I stand to be corrected, that is not part of the evidence and you're asking the witness to speculate. Hence my interjection before I even entertain Mr. Takla Singh's objection.
Madam Chair, I am trying to assist this panel to understand from Paria's perspective so that we can all get an understanding as to why they made the changes that they made. And I am about to go into the changes. And in fact, in this particular marine tender, there were several changes where technical criteria were changed. One of them is the requirement that all officers, as Amalgamated has all officers fluent in English. That was a requirement in the July tender. It has been removed in the October tender. There are other issues as well that have been removed in the October tender that I will be asking these two witnesses about, because it's about fairness.
Right.
Where you, and I'm looking at the evaluation records. No, but you know, we have been under a serious time pressure here with thousands of pages of documents. We are having to go through 3 different tenders and go through it with a fine-tooth comb, Madam Chair, so that this was not specified in Form 8, because we did not have all of the information to specify certain things in the Form 8. Their Form 9 came in a few days ago. And so we are working through this. Sorry, Madam Chair. Yeah.
Right. So what I'm saying is that your question, you need to rephrase it then. The question was asked as though you're asking it to speculate. If that is the evidence, then you can say, you can either put it to him that these were the changes, or you can ask.
But I'm going to, Madam Chair, but it's the way I approach the question.
So the question was phrased like it was he's been called upon to speculate. So perhaps you need to rephrase the question, right? So that's clear that this is in fact one of the requirements in the July tender that had been removed from the October tender.
I will take the guide. Of course, I will take the guidance of the chair and go straight to the question. However, I was not asking the witness to speculate. I was trying to understand what the witness thought about such a change because he managed the tender. I wanted to understand whether he would have thought that change was a fair and appropriate change, depending on the submissions. And then I was going to, which is why I've asked for him to be put out. So when I get his unrehearsed answer on that, then I would have put to him the changes in the document. So, I mean, sorry.
Sure, but what you need to do is get him to answer as to whether or not this was in the July document, and then you could proceed to the October. But the foundation came across like speculation, because if this is one document, would it then be unfair? It has to be clear that this was in fact in the document. Get him to accept or not accept, and right? It's just a matter of style, but it came across as if you're asking him to speculate.
I hear you.
And that can be unfair because the witness may not recall the evidence. And based on the way it's phrased, his answer may be. So it's a bit unfair.
I certainly did not want to be unfair, but I was seeking, and just for clarity, and with respect to the panel, I wanted to understand, because just like the panel, Paria is trying to understand, not Paria, Amalgamated is trying to
Amalgamated.
understand why Paria made the decisions that they did. Amalgamated feels
Yes.
that they've been very unfairly treated. Because when we start looking at the scores and seeing who was supposed to win, right, we have not asked for the award to be given to us. But we are trying to understand why certain areas where we scored excellently were removed in the October situation. Okay?
Understood. But so, Dr. Rose, we know what our aim with your witness. So
remember,
let us both be mindful, not just Dr. Rose, I also mean Mr. Taklalsi. So in as much as I would want to give you all the opportunity to respond on the objections, I would try to see if it could be determined once I can hear it one time and let you all know rather than go into the submissions. I hope you have no problem with that. Could we have the witness back in?
Okay.
Yes, Dr. Rose, you may resume.
I'm not seeing him. I'm not seeing the witness. Are you seeing the witness?
Oh, sorry, I took Mr. Dalai. Yes. Where's the witness? Yes, he's there.
Yeah. Are you seeing him, Chair? Just okay. Yes.
Ah.
Yes, we are seeing him.
Madam Chair, can the witness be shown the July invitation to tender? In terms of where to find it, it's in our Form 8, the one that we received. Our Form 8, page 46.
Yes, one moment, please. Page 46 of the Form 8. Is this the correct page? No.
Yes.
Is it numbered 46 or is it?
Yes, PDF 46.
Yes,
this is a
PDF
page.
46.
This is a page. If we can go down to 5.13. Mr. Subaru, do you see 5.13? Personnel must be fluent in English.
Yes, ma'am, I do.
Would you say that that's an important criteria?
I will say yes, it is.
From a security perspective, yes?
Yes.
That, when officers are speaking to each other, or if the officer has to alert someone else in a different area, that's pretty important from a security perspective. Would you agree?
I would say yes, ma'am, it is.
And you were responsible for compiling the scope of works, yes?
Yes, I was.
You were about to offer something. I'm happy to hear it.
What we have seen in previous situations, bidders offering crew that are non-Trinidad and Tobago nationals, from Spanish-speaking and other countries. And this is what this particular comment there addresses.
Thank you. Can the witness now be shown the October ITB? Can the witness now be shown the October ITB, which is on the same bundle at page 1,419?
1,419. Is this the correct page, Dr. Rose?
Yes, please. Yes, please. Can we scroll up? we're going to look for 5.13.
5.13. There's no 5.13. And then 5.12.
Yes. That is the point.
You
Are
want to ask
familiar-
me Mr. question?
Yes. This is your October invitation to tender that you put out.
Yes, it is, ma'am.
Is the requirement for officers to be fluent in English here?
No, ma'am.
Then you were responsible for this document.
Yes, I was.
And would you say that the technical criteria, therefore, here was materially better or worse in the October invitation to tender?
I am not clear on the question you're asking in terms of better or worse.
Well, did we not just have a little discussion on the purpose of having officers being fluent in English?
Yes, ma'am.
Okay. Is it that there's somewhere else in the tender where you may have put the requirement of being fluent in English? You changed the document in many places, did you?
In some places, yes.
In some places, you changed the tender. Yes?
In some places, we amended the document, yes.
And now you accept that you amended it in terms of fluency, the officers needing to be fluent in English, yes?
It wasn't included in this particular document, no.
In the tender.
That's right, in this tender.
And so do you not see the technical requirement as being degraded? Because
No,
it
I
now,
wouldn't say it's degraded.
what would you
I
say?
would say that
It's
it was
less.
omitted.
And therefore, contractors were required to provide less information.
Okay, 1 minute now. One before don't answer. Sir,
Chair,
Chair
object.
objection.
Yeah, Chair, I'm objecting
Yes.
this issue. Chair, I'm objecting. This issue is absolutely not pleaded anywhere in the grounds or the format. And the law, the rules are very clear. The panel has to determine the issues that arise in the format and the form 9. There's nothing about, in fact, it's not even raised in the witness statement as a complaint. So there's absolutely no notice at all to Paria that could have allowed them to answer this. So it is absolutely unfair. It's an irrelevant issue. And in any event, the limitation barred, because you had a problem with the solicitation document, again, that had to be raised prior to the close of the tender. That's very clear in the act. So this is a totally irrelevant line of cross-examination. Not any grounds, not any relief, not any format, not any form 9, not any witness statement, not any disclosure. Well, I'll retract that one, but and not raised anywhere. It's not even the submissions that we filed, not raised in the CMC issues. So where are we going with this? That there's if there was a difficulty with fluency in English, that should have been pleaded and notice should have been given. So we're wasting time with the issue with respect. Yes, I think it's irrelevant. That's the point.
Yes, Dr. Rose?
In our Form 8 on ground 4, we took issue with the cancellation and reissuance of the tenders in breach of the objects of the Act. We are saying that the evaluative criteria, and I'm quoting from the ground, was materially altered without explanation after it had already received ASSL's full technical and pricing submissions. We did not have all of the details at that time. We are looking at the disclosures and we are looking to see why did they cancel this tender after evaluating? How have they changed their submissions? Are there questions that are raised in respect of how they have changed their submissions? that would favor one contractor over another contractor. This is the work that we are doing here. We are reviewing the tender process. We have joint issue. It respected the degrading of the evaluation criteria in our Form 8 grounds. The fact that in this severely truncated procedure, we have not put every single particular that we may want to raise, certainly cannot preclude us from identifying the changes in the documents which are before the panel. It is before you. So is it that the panel is going to look at it?
Thank you, Dr. Rose. Thank you, Dr. Rose. So I would tend to agree with Dr. Rose. It falls within what has been pleaded in ground 4. The specifics of the changes were not itemized, but the issue of the changes was raised in ground 4. So let us proceed, Dr. Rose. Is it that you have another objection, Mr. Taklalson?
Well, my friends had the ITBs for months now. So for her to suggest that a lack of disclosure has prevented her from raising that issue, it's untrue, and it's not in the witness statement. Both ITBs were in their possession for months. So it can't be that.
Notwithstanding, it was not raised in the witness statement. It is an issue that arises from the Form 8 that was filed. So we will proceed.
But then it's statute bar. All right, much obliged.
But it's statute bar. The entire conduct, the issue of the entire conduct was pleaded. So in as much as it falls under one of the grounds, we will allow it. If it goes outside and goes into details of the July tender that was not relevant to what has been pleaded, then I would accept that. But in this case, it deals with the circumstances surrounding. So,
yes,
Dr. Rose,
yes,
you may proceed.
Right. I'm going to move to another change, please, Madam Chair. One of the...
Dr. Rose, please be mindful of the time, please. We are way over the time now.
Let me see if I can do this with this witness in a general way. In my respectful view, the ITBs are before the panel. I am going to ask this witness, who was responsible for compiling the scope of works, the reason for the changes, that he understood the reasons to be, and then in submissions, I can submit on every single thing, that is there. My learned friend also has in his possession both of the ITBs. It's an evidence before the panel, and I would be urging the panel to be looking closely at the ITBs to try to understand why was this cancelled and reissued in a substantially different form.
Yes, please. You can deal with the submissions. I agree.
Yeah, thank you. Mr. Sobero, so you were the one responsible for July and you were the one responsible for October, correct? We've agreed that, yes?
Yes.
Right. You said that you canceled for a technical reason, yes?
Correct.
Would it be fair to characterize your evidence that even though you canceled for a technical reason, you took the opportunity to make changes, more than one, changes to this invitation to tender in October?
Yes.
What was motivating you to make those changes? We want an explanation for the changes that the panel is going to have to look at. What was in Marine, what was motivating you to make these changes?
Some of the changes that were reflected in the October tender was an attempt to increase the number of suppliers that could respond to the tender, because marine security is what we call a niche capability with limited providers for that particular tender. So the opportunity was taken to open the submissions or open the, sorry, not submissions, to open the response to our requirements by removing what we consider to be limitations.
Thank you. How many tenderers, how many bidders were there in the July exercise?
I can't recall right now.
But it would have been recorded in the disclosures that you sent to us, yes?
Yes, the information was included.
And so we will submit on that. 1 minute, please. I'm mindful of the time, Madam Chair, but I think I do need to point out one more change. There are others, but there is one that I do want to place before the
Yes.
panel. Now, sorry?
I was about to say, if you need to place it before the panel, it will be done in submissions. If you want to ask him on it, ask him about it, then
I do want,
you could proceed.
I do want to ask him about it. Yes? 1 minute, please.
Yes, proceed, please.
I think we can address it in the closing submissions, please. I think the point is
Thank you,
made.
Dr.
Yeah, okay.
You have
No
any
further-
further questions? Witness?
No further questions, please.
Thank you. Mr. Subaru, any re-examination by Mr. Taklazi?
There is a.
No, Chair.
Thank you. So let me just ask the other panel members if they have any questions. That's it. No questions. So thank you very much, Mr. Subaru. You're relieved. We'll put you out of the room and may you call your second witness, Mr. Taklazi.
Thank you, ma'am.
Yes, Chair. Just send my junior to exchange the witnesses, so to speak.
Yes, please. So before we go to the next witness, everyone who is in the room, your camera should be on. So we're going to remove persons who are here, Mr. Mahias, Ms. Mohammed, and Mr. Ragunanan, I think, yes. You are not allowed to switch the cameras off without the leave of the panel. Yes, and Mr. Mahias, we are going to remove now. Is the witness here? Right, Ms. Rabir, your camera needs to be on. Right, Ms. Rabir, you are going to hear an oath. You have to repeat the oath. Let us know if you're having any difficulty.
All right, she unmuted. Leave it.
Good afternoon.
Ms. Rabir, are you hearing us?
I am now hearing you, yes.
Good afternoon. Please raise your right hand and repeat after me. I state your name.
I, Marissa Radber,
Solemnly swear
solemnly swear
that the evidence
that the evidence
I shall give
I shall give
to the hearing panel
to the hearing panel
in this case shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Ms. Rabir, you can take your hand down. Mr. Taklal Singh. Oh, sorry, yes, Mr. Taklal Singh, you proceed. Lead it.
Yes. Ms. Ragbir, are you hearing me?
Yes, I am.
Ms. Ragbir, hello?
Yes, I'm hearing you.
Yes. Could you please state your name for the record
I'm Marissa Radber,
and your position?
Contract Services Coordinator.
Right. And you remember giving a witness statement in this matter?
Yes.
Right. And if you were to see that witness statement again, would you recognize it?
Yes, I will.
How would you recognize it?
By my signature.
Okay. Take a look at that document. Is that your signature?
Yes, it is.
And the contents are true and correct?
Yes, it is.
Chair, could the witness statement be tendered and marked?
Yes, please. Witness statement tendered and marked. Ms. Rabir?
Yes.
We have some questions.
Sure.
Good afternoon, Ms. Radweir.
Good afternoon.
So how long have you been employed with Paria?
The 11th of November, 2019.
2019. And since then, you've been in this position, this
That's
contract
correct.
services coordinator position.
That's correct.
And so you've been involved in many tendering exercises.
Yes.
Do you have any procurement training?
Yes, I do. I am CIPS qualified.
Up to what level?
Level 4. Pursuing level 5.
So you are very familiar with requirements in a tender process?
Yes, I am.
And what would you say is your understanding of the Procurement Act? The Public Procurement and Disposal of Public Property Act. Would you say you have a high level of understanding or, you know?
Yes, I understand the Procurement Act, role and function.
Yeah. And what is your position vis-a-vis the named procurement officer?
What is my position?
Yeah.
Sorry?
What is your position vis-a-vis the named procurement officer?
I work directly under him.
Ah. So everything you did in respect of this tender, you got the approval of the named procurement officer?
That's correct.
Okay. So what was your involvement with this marine tender in October? What did you do in respect of this tender exercise?
I would have reviewed the tender documents. I would have did the bid selection. I would have scheduled the virtual meeting. I would have hosted the meeting as well. We would have facilitated the opening of the tender, the collection of the bid submission. We would have overseen the evaluation. We would have reviewed the PDAC recommendation note. We would have issued the standstill letters. And I would have also sat in the debriefing meeting.
Right. So tell me something about this evaluation committee for this October tender. You all had meetings?
Yes, we had meetings where we met as a group.
And you have notes from that meeting? From those meetings?
I don't have individual notes. What we would have done, we would have sat together and the records would have been kept on the Excel sheet where we would have indicated, where the evaluators mainly would have indicated acceptance, rejection, and whether the person would have met the qualifications or not.
So how many meetings did you have?
It was several days. I cannot remember specifically how many days we took for the evaluation.
Now, who were the persons involved in this evaluation?
It would have been the security lead. It would have been another security representative.
That's Mr. Subero.
Mr. Subero, that's correct. It would have been Mr. Colin Rodney. I'm not too sure of his position. He's also in security. And it would have been Mr. Manmohan Balkaran, who was the independent person in the evaluation team.
What was his position?
His position is technical lead.
Technical lead, but not security technical lead.
No, the security lead is Mr. Subero. So we had an independent person on the evaluation.
And that person is an employee of Paria?
That's correct, employed as the technical lead.
And who was responsible for the commercial evaluation?
Mr. Subero. For the marine tender, yes, I am.
Who is it?
Allied.
And they are also the ones that you decided you gave notice that you wanted to award the contract to. Yes, on March 11th.
Yes, that Paria intended to award to Allied.
Now, this is the second time that Paria has gone through this process, yes?
That's correct.
For this contract.
That's correct.
You were involved in the first
July ITV, yes.
And so you are aware, and from your recollection, what was the reason for the cancellation of the first one?
The July ITV?
Yes.
When we are using the eBox tender platform and the technical evaluation was completed. However, we are required to upload the evaluation scores into eBox so that we can reveal the commercial evaluation. And when we started to do that, before we could have finished upload the technical, we started to see costing. And when I say costing, I mean just the lump sum costing and not the access to the rate sheets. So when that was disclosed, we realized that there were vendors' prices being shown for who did not pass the technical evaluation, and that was a breach in the process.
You were there at the debriefing meeting. You didn't say that, did you?
No, we did not go into the details in terms of the internal issues that we would have had with our e-box platform.
Is it not true that at that debriefing meeting, you indicated that you had difficulties extracting the submissions?
I don't recall if that was the exact wording. If that was an error. It was not extracting the submission. It was when we were uploading the technical, we were unable to complete that.
And at no time in that debriefing did you indicate to Amalgamated that you had in fact embarked upon, engaged in, and completed a technical evaluation?
Well, the technical evaluation was completed in paper, but it was not completed in uploading on the e-box system, which is the e-tendering platform that we used.
Yeah, but you did not indicate to Amalgamated at that debriefing that you had opened the technical submissions and evaluated them. You did not, did you?
I cannot remember if that was a question or that was a matter pertaining, but we could not have not access the document. I'm not sure if that was mentioned, that we did not access the technical document because we needed to look at the tender.
Right. So are you saying that you didn't say? I don't want to spend too much time on this.
Yes, I don't recall saying that we could not access the technical documents.
You don't recall saying that? Because if that was said, that would be wrong.
That's correct.
Remember what was said?
I remember they asking us why we had to cancel the tender, and we did not specifically identify that it was an issue on our platform.
Sorry, you recall saying you didn't identify it was an issue on your platform?
Yes.
You did not?
No, we did not.
What was the reason that you gave, that you remember giving?
We told them we had experienced some internal issues.
Okay. Is there any reason, but is there any reason you didn't say more than that?
No, there is no particular reason that I could specify at this time.
The debriefing. What in your mind was the purpose of that debriefing exercise?
For Amalgamated to, I guess, gather information as to why they were not successful in winning the tender.
And did you come prepared to give Amalgamated the breakdown of their scores at that meeting?
Yes.
And did you give them the breakdown of the scores?
What we would have asked them to do is to write to us exactly what is being required, and we would have provided a response to them on that.
Yeah, but did they not ask you in the debriefing what their scores were?
Yes, and we did go through some aspect of it, but when we started to get into a lot of...
Correct?
Sorry?
But not all of it.
Not all of it, because when we started to go into it, there was a lot of information being requested, and we asked them to write to us, and we'll provide a response to them.
Now, it was a technical reason, you said, why this July tender was cancelled, yes?
Yes.
Yet, it is true to say that Paria, having this technical issue, maybe as a gift, it happened, you got this gift, you then decided to materially change the tender requirements. Is that correct?
I was not responsible for changing the tender documents. That is a technical function for Mr. Sabero.
But you are a procurement practitioner, yes?
Yes.
You are would you consider yourself a procurement expert?
Yes, and Mr. Sabero is responsible for the technical aspect of the contract.
And you're responsible for, under Mr. Mohes, for probity and correctness in the tender process, yes?
Yes.
Now, you would accept that if after opening tenders, conducting a technical evaluation, seeing commercial submissions, you decide to cancel and retender with materially changed technical requirements, that raises issues. Would you accept that from a probity perspective?
Well, just to correct you, we did not see the commercial submissions.
Oh, so you didn't see, oh, but you saw the commercial pricing?
We saw a lump sum price that could not determine the rates for the officers or any sort of details on what the submission entailed. Because this was a unit rate contract, so we needed to view the document to determine the rates assigned to each personnel.
They saw the lump sum pricing. Yes? That's what
yes, a price was shown.
Yeah. And yet, I mean, you accept that when you retendered, you changed the commercial methodology?
Yes.
Why did you change the commercial methodology?
Well, the guidelines that we got then was that we needed to improve to ensure that we were paying that the incumbent will pay the employee better wages in terms of better packages in alignment with industry rates. We wanted to ensure the employee would benefit.
The guidelines you got from who?
That was then the former GM that we had.
So you decided to change the requirements internally?
I did not decide. The directive came from the office and we would we considered that, and yes, we agreed to it.
Right. So, madam, you are here representing Paria. Okay. So when I say you, I don't mean you personally. I mean Paria. Can we accept that?
Okay.
You decided internally to change the commercial methodology on this tender.
Yes.
And you did not put that into the invitation to bid that Amalgamated participated in.
We would have had some sort of description in there saying that the vendor or the commercial assessment will be done in alignment with industry standard rates.
Yes.
We would have accepted that during the debriefing meeting, two vendors would have raised concern on the methodology raised, and we would have looked at that and determined that we could have clearly articulated it a little bit more detail, and hence the reason the cancellation notice was done.
Yeah, I didn't ask you all that to know. I asked you, you made a decision internally to change the commercial methodology, the way you were going to evaluate the commercial proposals. You said yes, correct?
Yes.
And it's quite an involved thing there. We haven't even gone into all the ways and you've done it, but here you've talked about you had guidance from the GM to look at the rates that bidders were paying compensation to officers, correct?
Yes.
You just said that.
Yes.
Right? Is that anywhere in the invitation to tender?
No, it was not explicitly stated.
Well, it was not stated. Was it, Ms. Rabir?
Correct.
Now, you know, on this tender, Amalgamated, you must be aware because you were involved in this, had a lower price than the contractor that you signaled to everyone that you wanted to award this contract to, correct? Yeah, they had a lower price.
Yes.
Right? They also scored higher on the technical. Is that not correct?
Correct.
And then you decided, you've assessed the proposals and you've seen that. You then decided to apply an internal methodology that you did not put in your invitation to tender. And it is on that internal methodology that Amalgamated lost out on this contract. Is that correct?
Yes.
And you are the procurement officer. I guess Mr. Mahes just wants to stay in the background. as the named procurement officer, and he's put you in front to come and, stand the bounds, and you as the procurement officer thought that that was an appropriate thing to do, having regard to the provisions of the Public Procurement and Disposal of Public Property Act, madam?
Probably we have to answer the question.
Chair, I don't know what the question is.
So you thought it was an appropriate thing, you thought that that was an appropriate thing to do in accordance with the Public Procurement and Disposal of Property Act, to have assessed bidders, and on the express criteria, you have a bidder who is higher technically, has the lower price, and then apply an internal methodology that is not on the invitation to bid. You thought, as the procurement officer, the person standing here representing Mr. Rajendra Mahej, the named procurement officer, that that was a correct thing to do in accordance with the Public Procurement and Disposal of Public Property Act?
Ms. Ravi, don't answer yet. Mr. Taklal Singh, objection? Do you have an objection?
I would ask.
Yes, I have to object, but
this is quite sensitive, so I would ask that this witness be put out before Mr. Taklal Singh responds. I know it's
I was going to suggest the same thing.
Thank you, Mr.
Right.
Taklal.
So, Ms. Ravi, you're going to be placed in a room. You would have to accept when you see it on your screen, and you're not to speak with anyone whilst you're in the waiting room.
Okay.
In the breakout room, I should say.
Okay, sure.
Ravi, are you seeing it on your screen? Lovely. Mr. Taklal Singh, you can proceed.
Yes, the question is unfair because she's reciting the wrong facts. Ms. Ragberry said that some of it was there, and she pointed specifically to alignment to industry rates. Nowhere did she say that the lowest bid was the criteria. What my friend's question is trying to say is that there was something improper because Amalgamated had the lower bid. That is absolutely not true in terms of what was in the ITB. And Ms. Ragberry clearly said that some of the criteria was there, and she pointed specifically to alignment. So that I can't see how Ms. Rose could be asking her whether something was improper because of a lower bid. That's a totally unfair question, and she's misleading the witness. She's leading the witness down the wrong track. She should say, oh, I'm not going to tell her how to ask a question, but the point is that the witness did already say alignment, and that's the criteria. And she said that some of it was there. So don't put it to her that she said nothing or that it's absolutely not there. Some of it was there. And the words alignment exactly was there. So I think the question is unfair in the way she's asking it.
Alignment, Madam Chair, I don't know if you want to rule without
She said alignment.
But the issue is not that. This witness has gone into depth.
That is the issue. That's what is in the ITB, alignment to industry rates. That's the standard.
Okay, Mr. Taklal Singh. Mr. Taklal Singh.
Yes.
Ms. Dr. Rose, you're correct me if I'm incorrect, but the question was whether she felt it was appropriate, notwithstanding the lower price and the higher score.
And that's the unfairness.
Company.
And that's the unfairness because the standard, and that's the unfairness. The standard isn't lowest. It's alignment to industry rate.
So I understand. So
yes.
So Mr. Taklal, I understand what is your rate, but that is not the question that I understood to be asked. The question was because Dr. Rose appeared to have laid the foundation about her knowledge about procurement, and she's asking her whether she thinks that was appropriate to do.
But what was appropriate, Chair?
Is
it the inclusion in the ITB of alignment, or is it that whether because if it's an award in relation to alignment, then that's an unfair question. But if it's the inclusion in the ITB Well, that's a different question.
May I respond to Melinda very, very quickly?
Yes,
What
yes,
the witness has, what the witness has said is that they got guidance from a GM that they had to look at the compensation packages for officers, and they had to take that into consideration. She then said that is an internal methodology. She then said that is an internal methodology that is not captured in the ITB. In the ITB, we are all at EDM, that it is alignment with industry rates. We are all at EDM, that is what was put in the October ITB. But what was not put in the October ITB is the internal methodology that this witness just gave. And I am asking her in the context of a bidder who has the highest technical score and is lower than the bidder who was awarded the price.
That's the problem.
Yes, lower than the
problem.
bidder. Because under the Public Procurement Act, Madam Chair, Section 5(1) speaks to value for money as an objective of the Act.
But value for money, but it doesn't mean lower price. It could never mean lower price. Alignment of industry standard.
No one is saying it means lower price. Alignment of industry standard. That is not what this witness indicated was applied. It is not the internal methodology.
She did say alignment. She did say alignment.
Okay, so
yeah.
So we're not going to belabor the point. The objection is overruled. Dr. Rose asked the question. We have the witness back in.
Right, sure.
And Chair, I just want to add that this is a wholly statute-barred line of inquiry in terms of the makeup of the tender document. So that will be in written submission, but wholly statute-barred.
And no, I'm going to respond because anyway, the witness is back. But failure to disclose criteria is certainly not standard. Anyway, moving on. Ms. Ragbir. So the question is, do you think it is appropriate under the Public Procurement and Disposal of Public Property Act to have an ITB with specific technical and commercial criteria in which a bidder scores the highest technically and then on the ITB has a lower bid than the one that you want to award it to, and apply an appropriate, do you think it's appropriate to apply this internal methodology that you just recounted for us in such a circumstance that is not the internal methodology that's not in the ITB to then award it to another tenderer?
Based on what our intent was to ensure that the officers were being compensated adequately, that was the intent with respect to not awarding to the lowest priced vendor.
Yeah, but not the lowest price. We're not talking about the lowest price. I'm talking about you are responsible for probity under the Public Procurement and Disposal. Well, your boss, the person to whom you report. Yes?
Yes.
You are aware that you applied and you've already accepted that you applied criteria in the commercial evaluation that was not in the invitation to bid. Is that correct?
Yes, and we admittedly said it was an error.
And you thought that that was appropriate at the time?
Now, the reason why at that time there was no objection, because, no vendors raised any objection at that time. So we thought that in our mind, we would have explained it fully. It's only when we had the debriefing meeting and vendors raised objection about the methodology used is when we realized that we could have clearly articulated it a little bit more details.
Oh my, my.
So is that a question?
Oh, please. You are the person responsible for probity under the Act? Did you not
Yes.
raise a red flag at any time that we can't apply a methodology that's not in the bid?
No, I did not raise an objection then.
Did you advise anyone, Mr. Mahias, that it is not appropriate to evaluate tenders on a basis that is not in the bid?
No.
Now, you are aware that in addition to not disclosing all of your commercial methodology, which you've accepted in your notice of cancellation, you are aware, and you can tell me I'm wrong if I'm wrong, that material changes were also made to the technical criteria.
Yes.
Oh, thank you for not making that difficult. So you had a technical glitch, which caused you to see these submissions.
Yes. Hold on, Dr. Rose. Yes, Mr. Sanglasing.
Chair, this is the third round of questions to this witness about the technical glitch, and it is now 2:37. This is unfair. I limited my cross-examination. I was able to efficiently address all of my issues in the limited time. My friend is now going way past her time. This is the third time we have to hear about this technical glitch. And I'm glad she's calling it a technical glitch now. That's what it was. So I am objecting to any lengthy cross-examination on this issue, and I think she needs to be limited. Because it is now unfair to give, we already have a compressed deadline today, and it is unfair to allow all of this time. It is now almost 2:38, and I was told I had 45 minutes. Or else I would have had Mr. Dalai here still answering questions about probity of Amalgamated. So it's approaching 2 hours, so it's unfair.
I have not been cross-examining for 2 hours.
Well, more than the allotted time.
Full aware that he cross-examined for much more than his allotted time.
Dr. Rose,
No.
Dr. Rose, okay. You all let us avoid the back and forth. I agree that you're over your time, Dr. Rose, because you got a specific time for the two witnesses. You have spent significant time on the first witness. So there are issues that can be addressed in submissions.
Yeah, but I need at least one point. Yeah, we need to discuss there is one point that I have to discuss with this witness.
I'm not stopping your cross now. I'm just warning you that there are some things that you can leave for cross-examination. For submissions.
But Chair, I am objecting because cross-examination time was limited for me.
Yes, it was also limited for Dr. Rose as well. But
and she's exceeded.
Dr. Rose, how long do you have again?
What I could do is close with one issue. Yes?
Yes.
There's a lot more, and this is why I said at the beginning of this, there are serious issues that we wanted to raise in respect of this tender. We don't have enough time to raise it.
Well, no, Dr. Rose,
respectfully. Yes. Sorry.
Part of the delay today was on account of your request for the redacted documents. Had that been made earlier, we could have come here today and you would have had sight of it before. So we had to take time to consider that, right? So you have to bear that in mind. That is part of the reason we have been delayed today. And that was something that could have been dealt with had we gotten that request, even by a letter last night.
I understand, and I take your point on that, but I think that would have cost us maybe 15 minutes, 20 minutes max.
No, Dr. Rose, we spent a lot more time than that. We stood down to consider it. We made the order. We then stood down for it to be redacted and sent to you. That took almost an hour.
I'm not going to, I certainly am not going to go back and forth with the chair.
Because we spent back and forth at the start on it.
But I would say this.
Continue with your course.
But please, I do want to say this, that the panel made an order for disclosure, which the respondent did not. Okay, I'm just going to move on. One final point. I will go with one final point with this witness.
Yes, please.
Madam, in respect of the July ITB, invitation to bid, you would have had requirements in there for the bidders to submit their litigation history,
Yes.
litigation matters. And in fact, in the technical criteria in July, you had 4 categories of information that was required.
Yes.
Under technical criteria, you had a table 2 in the July ITB. Is this? We can put it up on the screen very quickly. In Form 8, page 49.
Yes, please.
Form 8, page 49.
Page 49. Let's get that up on the screen. Get that up shortly.
Yes. Yeah, page 49, please. And if we go down, this is the evaluation criteria in the July ITB. If we can scroll up, please. Well, there's litigation matters there, yes. And then if we can continue to scroll up.
On page 48.
49, please. Yes.
Table down.
Yes, please.
Go down.
Go down. Table 2.
Down.
That's it. Table 2.
Table 2.
You
Yes.
see that in the July ITB, you are familiar that this was how you broke down the technical evaluation criteria. Resource
Yeah.
capacity for 40, bidders' work experience, similar contracts and references for 30, execution plan and quality assurance for 20, and litigation matters and statutory compliance OSH for 10. That made up the
Yes.
100. Yes? Did
Yes.
you reproduce that in the October ITB?
Yes, the litigation matter came under the preliminary evaluation where we would have sent a litigation form for them to come, for the vendor to complete.
Also, did you change it from being part of the technical evaluation criteria?
So it would have assigned, it was assigned in the preliminary evaluation with a yes or no pass.
Just yes or no?
Yes.
Meaning whether you had litigation or not?
Yes.
So you no longer wanted to score people on litigation and statutory OSH compliance?
That is what was, yes.
Now I want to go to the October ITB where
What is the page number, please?
Yes. We are pulling it up. Is it 1,000 for? Yeah, apologies.
1,409.
Try 1419. I don't know. I think we went it earlier, and that was where we went to. But I'm.
Oh, right. That would be 14.
What
1419. We went to 14.
Right. So that is the second one. But we're now going. If we can scroll up, we're going down to where the tables are. So 9. We're going down. We're going up. Evaluation criteria, yes.
So up to the technical, the second table. The second table, doctor.
1423 is the table part.
1423.
1423, yes. But there's more to be said. But so Ms. Rugby, I'm going to try to be really quick. I am suggesting to you, and we will see it. There was no table 2 in the October ITB. Is that correct? You left it out entirely.
Yeah, that's correct.
So bidders would not have been able to know what was going on there. Would you accept that?
Yes.
Also, in the summary of evaluation criteria, technical 50%, bidders will be awarded points based on alignment with the technical evaluation items as defined in table 3 above. There is no table 3 above in the October ITB, is that correct?
Yes, but the description of technical evaluation is there. Yes.
The description of technical evaluation is there. Let's scroll up and see what your description of technical
Right there,
evaluation.
table 2. I am table 3 is an error and it was supposed to reference table 2, right?
Okay, so where is table 2? There's a heading table 2, but where is table 2?
I'm not able to see the upper part of the document. Can we scroll?
Can we scroll down, please?
Would you like us to go to 41422?
Sure. We can see if it's higher up.
We would have accepted that the table was missing.
The table was missing. And in fact, when you served your notice of intention to award on March 11th, you had a table there, correct?
Could you just repeat that question? When we served the...
It's in the March 23rd disclosures.
Yes, when we had to provide the response to Amalgamated.
You put a table there, correct?
Yes, identifying the scores for the 3 submissions, yes.
Right. Do we have the page so that the panel can see it?
Chairman, if my friend needs to point out a table, that could be done in written submissions.
Well, there's a point I'm coming to. In the table, in the technical evaluation criteria, I will just go straight to it.
This is
So, okay, Dr. Rose, sorry. Mr. Taklalsing, I'm hearing you. Right. Dr. Rose, the other matter starts at 3 o'clock. Is it that you have a question to answer on the table or you need the table? Which table do you need us to? Are you wrapping up?
Yes, I am wrapping up the point, which is the technical evaluation criteria in July, the table 2 had litigation in it. In the ITB in 032, in the second ITB, there is no table, but then when they provide us.
Dr. Rose, hold on.
Yeah.
Just asking if you're wrapping up in terms of the questions that you're going to ask, right? Do we need the table? We wouldn't look at the documents. You can reference the documents in the submissions. So,
yes.
So that's, I'm trying to, so you can put the question to the witness.
Yes. Yes. And we just now at page 2508 on this document. If we can just, and I will wrap up on this to the best that I can do. And scroll down. So this is your notice of decision to award that you sent to Amalgamated, yes?
Yes.
And in it, there's a technical evaluation items, which formed no part of what you provided to the bidders, but as they said, they did the best that they could based on what they thought was there before. So you see here, you've removed litigation matters and OSH and all of that from here. Is that correct?
Yes,
that was not one of the.
Yes,
that was not one of the 4 categories.
That is correct.
You reduced it to 3.
Yes.
You have any explanation for that for the panel?
The litigation aspect of it, as I said, was done in the preliminary evaluation. On the documents to accompany the submission.
But it was just a yes, no. It was just a
yes,
yes, no. You just
yes.
Said. And you were aware that in the July ITB, Amalgamated.
Mr. Taklalsing, hold on. Dr. Rose, yes, Mr. Taklalsing.
Chair, I'm objecting again. This is another issue we're going on to in cross-examination. We have 9 minutes for the next hearing. And in any event, again, if something was or was not in the solicitation documentation, I am sure that is a limitation. She's statute barred from that. It might be a different if there's a criteria not used, but if she's complaining now about what is in the document and what is not in the document, then that is a statute barred issue for sure. So it's totally irrelevant. 8 minutes again.
Right. Madam Chair, we are not talking about what was in and what was out. We are talking about what the changes were made. What were the changes that were made on this ITB for this October process, looking at the issue of fairness of this process toward amalgamated. Because, you know, and in
Dr. Ross, these inconsistencies, you can't point them out in your submissions. We got the point.
But it's not just that it's different, but it's also about Amalgamated's position on these. Amalgamated would have scored top points, having no litigation, having put all that in July. And another bidder may not have had that.
We gather all of that, but you could ask a specific question without going into the actual inconsistencies. You can point them out in your submissions.
Yes, I will do that, and let me just let me just put something finally to Ms. Ragbir.
No.
Ms. Ragbir, I am putting to you.
Put something up.
That's based in the submission. That's based in the evidence. The evidence would be attached to the Russell Dalai statement, which attaches the ITBs. So if you don't want me to put it,
you're going to put to the witness. That is an unfair question to put.
Yes.
Because you're speaking about Russell Dalai statement.
Sorry?
No, but you started off by talking about Russell Dalai's witness statement.
Yes. Yes, Madam Chair, I'm listening.
Right. So is it you're making a specific reference to part of the witness statement?
I am going to I'm referring to the ITBs, which is what I'm going through with the witness who was responsible for these ITBs.
Yes.
If Madam Chair, if you are saying that we can put whatever's before the panel already in the ITBs and in the submissions, I can make my submissions on that. Well, then I will.
Yes, you can. If it's already in your witness statements, you can make your submissions on it. We don't have to go through every single inconsistency that you've noted. In cross-examination, that is. You are free to do it in your submissions. Do you want to put something down before we end, or that is it?
I will rest. I will rest.
Thank you very much. Any re-examination, Mr. Tackler?
No, Chair. No, Chair.
Thank you. Right, so we have a few questions for Ms. Ragbir from panel members.
Ms. Ragbir, could you perhaps explain to me the average size of contracts that you oversee in at Paria, and what would you consider? Would you consider the security contracts large or complex?
Yes, security manpower is one of the contracts, one of our contracts that we considered large and high value.
And what is large? What's the size of large?
Large in terms of the tender submission, the details of it, the process of it, the type of criteria that we use, the evaluation methods, sitting to go through the resumes and all of that. The time with respect to having the process completed.
So that's operational input, but in terms of cost, of contracts that you do award across the operations, these are about 3 million. Is that your largest?
No, that's correct. It's not very large, high value. That's correct. Yes, no, it will not be considered.
Okay. Okay, and they you typically take your contractors or providers off the e-box, which is about 11, I think.
Sorry, what technically you mean we use the e-box platform to invite vendors, yeah.
Okay, all right. A question in terms of your experience in SIPs, right? Is it conceivable based on a rubric and based on your objective as to what you want to achieve in your contract, that the rubric and depending on the weightings, a contractor could have a highest technical and a lowest price and not win the contract?
Yes, that could happen.
Okay, I'm trying to be quick. And if you were not to have amended the contract or the contract in terms of reissuing, what risk would you have faced? If you did not amend July, you did not amend, if you, I don't know if the implication is that you ought to have resubmitted the tender as is in July, in October. What risk would you have faced? What risks are there? What complications are there to have reached that process initially and then to continue it as is?
So just to be clear, you're asking the risk in changing the document from July to October?
If you did not change it.
If we did not change it?
Did not.
So in July there, we did not get a directive where we needed to, relook the submission in terms of fairness to the security employees and having standard industry rates where we wanted to ensure they were being benefited by more adequate compensation. So, that was one of the changes that we had in the bid. Other than that, we would have had to make some changes with respect to the number of officers that we needed for the job because as an entity, we needed more security personnel.
Okay. And the other question in assessing the commercial evaluation, do you take rates? You said it's based on unit rates. Yes.
Yes. Yes.
How do you treat with whether it's a reasonable rate, whether it is the structured banded methodology? How do you treat with rates that contract? Well, the providers may put that are unreasonable, either too high or too low. How do you treat with that? Do you just accept it in terms of your assessment of ranking a commercial evaluation?
It was measured against the company estimate that was completed based on standard industry rates.
Okay, and did that fall in the instruction regarding ensuring adequate compensation? Does that fall in line with that? Falling in line with an industry rate? Is that equivalent?
Yes.
Okay. Okay.
Thank you. That could be all, but Mr. Tackles and conductors, do you have any further questions based on what Panel Member Kelsey asked?
No, Madam Chair.
Thank you, Dr. Rose. Mr. Tackles?
I just one answer wasn't clear when a panel member Kelsey asked if it was a high value contract. I believe the answer I took down was no. I just want to clarify that answer.
In terms of the sum or the quantum.
Right. So it was low. I think the answer was it's not high value.
That's correct.
Yes, in terms of the value of the yes.
Yeah, it's not a high value contract. Yes, good.
Yeah, so this will bring us to the end. Do you have any? This is the end of the witnesses for the respondent, correct?
Yes.
Right. So we can wrap up now because we have to start the other hearing. We would have to get submissions by tomorrow because we have to deliberate. So in terms of, I can maybe. Yeah.
I'm prepared to do these submissions by 4 o'clock.
Right. Today? You mean tomorrow?
Yes, today.
Right. Okay. Well, great. Right. But we have until tomorrow at 4 p.m. The difficulty is if it comes after hours, it cannot be stamped and we cannot get access to it because it is a manual process. So if we say 4 and for some reason you need 5, you would need to indicate to us in advance so we can have the staff stay back to be able to access it at 5 o'clock.
So the direction is tomorrow,
right.
Chair, just being clear. Yes.
Tomorrow at 4 p.m. Right? submissions, closing submissions from both parties?
Please, may I be heard? If it is that
Yeah.
you must have the submissions by tomorrow. I am on a flight for several hours tomorrow. And so I would ask if we can have it for later than 4 p.m. If you can hold it open for later than 4 p.m. My flight is at.
And what time will be later?
I can try to do it maybe for.
This is really, we hear the blue.
So we can try to have it done for 6 p.m. please.
Yes, 6. We can work with 6 p.m.
You see, it's not as if both of us will be in transit.
I understand that, but it's just that we have to give the decision. We have to get an order out to you all by Tuesday, which means we need to have it at least over the weekend to deliberate. So we can deliberate and conclude by Monday. So 6 p.m. tomorrow.
Yes, please.
Thank you very much, please. So I would be taking my leave now, and you all will have another hearing, I think, shortly. Thank you very much, parties, and to all the witnesses.
Thank you.